Johnson tested positive shortly after the child's birth, made it impossible for the department to place the child with him. The drug charges that took place after that, or at least were pending after that, I don't know the current status of them, but I believe that they are pending, certainly contributes to the concerns the department has. The housing issue, the housing for such a young child seems, again, consistent with the evidence presented, that to be inappropriate and unsafe. So those two things together, I would ask the court to find that the probable cause is appropriate, or to find probable cause and schedule this and continue with proceedings.
All right. Thank you, Mr. Delaney.
Thank you, Judge. As the court and the parties know, these are complex cases because of the amount of rights that the law gives to parents when the state intervenes in their children's lives. And because of that, not every hearing is a critical stage. A critical stage in this case will be a trial in which the court exercises rights over a parent. Today, the question is, and this is for the benefit of my client, is there any evidence to continue and allow this petition to be filed? Very low. If the state presents any evidence, the court ordinarily authorizes that. So I explained to Mr. Johnson that his battle will be at the next hearing where the court wants to assert jurisdiction. Today, can the petition continue? Certainly from my experience, the court would find probable cause. We will nonetheless ask the court to dismiss today's petition, but I want Mr. Johnson to know his parental rights remain intact after today, and the court doesn't have jurisdiction over him at this time. That will be for the next hearing. But this is a probable cause determination as to whether there's any proof whatsoever that exists in this case, and the court certainly has heard so. At the next proceeding, we will then begin to defend vigorously, and we are doing that today, his rights as a parent, which remain intact. So in summary, Judge, the court's heard the evidence. We do ask the court to dismiss the petition.
Thank you. Ms. Hansel?
Yes, Your Honor. I believe the department has met the burden of showing, a burden of proof showing that this petition would be valid and would be appropriate at this time. I believe jurisdiction is appropriate.
All right. Well, the court will authorize the petition. I do believe the proof set out specifically the positive test and the housing situation are sufficient to allow a finding of probable cause, which the court will authorize the petition as to Mr. Johnson. The next step, of course, is a pretrial or mediation. Mr. Delaney, do you believe mediation would be helpful in this matter?
Yes, and the court anticipated my question. We often get to the pretrial, then go to mediation. We should probably start looking at that right at the probable cause determination, and it would move the case along more efficiently. Mr. Johnson,
right.
Mediation is a meeting without the court, without the judge, in a private setting. It's confidential, and we talk about what we can do with this case. And so I think that would be good. They've been very good in the past. It's not binding. You can still make decisions after that. But I recommend, and quite frankly, the court can just order it, but I recommend that we go to this informal setting where we can kind of meet, it'd be by Zoom, and see what we can do about the case.
I'll answer that question. I have one question before that, though. Is a camper, a nice big camper, consider proper housing? Because I've sent out 50.
Hold on, Mr. Johnson.
We can discuss that.
Right. You can discuss that at mediation, or otherwise I can't be involved in that discussion, and different people may have different opinions on that. But right now, I am going to order mediation. Once again, whatever happens at mediation is confidential, does not come back to me or to Judge Hessley unless there is an agreement. If there is no agreement, I do not learn. Hold on.
I'll agree to that.
Mr. Johnson, wait, hold on. I think the mediation needs to happen, but if you say anything at mediation, it's not like it can be used against you. I don't hear about it. All I hear is there an agreement or is there not? If there is, other than the agreement. If there's not, the matter is set for trial. So, Christina, if you could go ahead and establish a mediation, and then also for a pretrial after that.
Okay.
And I think we're only dealing with the father at this point, as the mother is already past disposition. So, okay. All right. I think that does take care of what we can do on this case. Mr. Johnson, well, do we have your current address?
It's the Hotel 137 West Street.
Okay.
You guys have that? Because I haven't been getting my mail.
Ms. Rice, is that the address that you have?
Room 260.
Oh, okay. I have room 202. Did that change to 260 now?
Yeah, and Miss Rice, you're more welcome to stop by. I thought you wanted to stop by after
Okay,
we got
Hold on. You guys can have that conversation later. I just need to make sure we have your correct address. Christina, do you have an address? Do you have it now?
So 137 West Street, room 260 in Gaylord.
Yeah,
Is that at a hotel? Do I need to put that on there?
that's at the Quality Inn, the same
Okay.
place we've been for months.
Well, she doesn't know that, Mr. Johnson.
She does though.
Okay, hang on. All right.
Okay, I
All
do
right,
have that.
we are adjourned, and counsel, if you're on the next case, that doesn't start till 10:30.
Very good. Thank you, Judge.
Thank you, Your Honor.
Objection to it. I explained to her what the situation was.
Okay, at this time, the court will grant the nollie, execute the entry. The defendant is released from bond. We need to do a commitment, Justin, because she's incarcerated. So, all right, thank you.
Thank you.
Would you like us at the podium?
Please. This is case number 21CR37999, the state of Ohio versus Teresa Young. Ms. Young is before the court with her counsel, Mr. Horwitz. Ms. Tranter's here on behalf of the state of Ohio. Ms. Young, I had you brought back because it's my understanding that you have been sentenced in Indiana. Is that correct?
Yes,
What was the sentence that you received?
9 years,
9 years?
yes. I
All
did 5.
Okay. And again, this case is fairly old. Looks like I sentenced you back in August of 2021, and I placed you into community control, but you've not ever been supervised by us, have you? Because you've been incarcerated, correct?
Yes,
All right. It doesn't make much sense to me to continue trying to supervise you or to postpone the supervision until you are released from prison. Do you agree with that?
yes,
So what was my thought is to bring you back here today with Mr. Horwitz to have you resentenced and just to give you a prison sentence that would run concurrent with your current sentence. Do you agree?
yes.
Do you have any objection to me doing that?
I'm sorry. Can I speak, Your Honor?
Yeah.
It's my understanding that she's done serving her Indiana sentence and she's now placed on parole for 4 years. And that she was,
Oh, she's been released from custody.
yes.
Oh, okay. I misunderstood. I apologize. I'm trying to read through these varying emails from the past month on Miss Young. What was probation's recommendation?
Yes, Your Honor, this is a bit of a complicated case. As you indicated, Ms. Young was initially placed on supervision back in August of 2021. However, immediately after her sentencing here, she did get transferred to Indiana and she was given a 9-year sentence, 5 of which she has now served, and she is now on active parole with Indiana. So she is technically eligible for release back out into the community. She was initially sentenced to complete a community-based correctional facility. However, at this point, since she has been incarcerated for such an extended period of time in Indiana, it is probation's recommendation that we do not move forward with the CBCF at this time, but that we rather release her back into the community. We would recommend that she continue on community control
Okay.
with probation at this time. However, she is going to be living in Lima with her sister, so we will likely be transferring her supervision.
Okay. So I just didn't read far enough. Okay. I apologize. I was confused. All right.
You had me confused for a minute.
I bet I did. Boy,
You had me a little bit scared.
scared. Okay, well, I apologize because it was not my intention to do that. Okay, so what I'm going to do is I'm going to change my previous order. I'm going to release you today. Do they want her on a monitor or something?
Your Honor, at this point, because it is the recommendation to transfer her supervision, we will not be requesting a monitor at this time.
Okay, so I'm going to release you today. Do we need a new assessment or anything?
We did get an updated.
Oh, you got it already. Awesome.
Yes.
Okay. All right. So you're going to need to follow the recommendations in that assessment. Okay. I'm going to remove the requirement that you complete a CBCF because it's no longer necessary, and your supervision will be transferred to Allen County. Okay. Do you have any questions? I apologize for the confusion.
No, we're straightening it out.
Good. All right. Anything else, Ms. Tranter?
I don't think so. I was just asking about her jail time credit.
Yeah. Let's do a jail time credit update.
23.
23 days.
23 days. All right, Ms. Young, good luck to you. Apologize for the confusion.
Okay, thank you.
Yep.
Thank you, Your Honor.
That's what I got in here from Ms. Gonzalez. You're not, are you?
From my understanding, Judge, last time I saw that the defendant was in court, there was some information revealed about contact with the victim. And so Ms. Gonzalez may have filed a motion to increase his bond based on his contact with the victim.
Hereby alleges defendants violated conditions of bond, specifically not having communication directly or indirectly with the complainant victim of the pending case, nor going near any residence, school, job site, or other location. State has reason to believe the defendants violated these conditions. He appeared with counsel in front of the court on June 16th and stated he had not had any contact with them. On the same day, the victim's mother called the district attorney to report who has in fact made repeated communications to her and her daughter, the victim, and stated he would take them to court to get custody if he was not allowed to see his daughter, the victim. The state contacted the victim's mother again on June 23rd and was informed he has been to the house where the victim and her mother lived multiple times and told them that he did not have a bond condition where he was not allowed to speak with them. Additionally, the victim's mother states he has called her multiple times wanting to see his daughter, the victim. Whereas state praise the bond amount be increased. That's what they're asking for.
Your Honor, if I may, in discussing with Mr. Rodriguez, he wants to obviously comply with all the conditions that are required of him.
It's not that he wants to.
Well,
he doesn't have a choice to, or else he goes to jail.
What I mean is he's not intentionally violating a court's order. If I may, Your Honor, when he was arraigned by Judge DeRuin, these were the conditions in terms of the order that the court will notice. These boxes were not checked when he was arraigned by Judge DeRuin. You have that in here. This is what I'm referring to.
See what's in the court's file.
No, she don't was only built by him. The two boxes that aren't checked.
Hold on, wait, what does state know about this? You just kind of picked it up, didn't you?
Yes, sir. I did speak with Ms. Gonzalez before she left, so I knew that the victim had made a call to our office letting us know. And based on the documentation that defense counsel has, it says no communication in a threatening or harassing manner. And based on the report from the victim, his communication was in a threatening or harassing manner.
On June 25th.
Yeah, go ahead.
You
I want to know.
What's wrong?
Yeah, raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, you have.
Lower your hand. Go ahead and give it your best shot.
Well, it's
Go ahead.
It's as far as
No, go ahead. Ask him the
the
question.
protective order that the court has indicated that it was entered on December. What was the date, Ron? December 16th.
Stand by. 15th.
15th. When you served with that, or did you sign anything indicating you received it? Did you know about it?
No, sir. The only thing that I got served on was the child support, and this one that I just got served last week.
And you say this when you're pointing to
The one that I got a hearing for this week on the 9th.
July 9th and the 3/17th. Is that
Correct.
right? That's. I'm still calls when you are here. That's clause number 26, DCF, 0782, the protected ones.
Yes, sir.
And you were served that on July 9th. I'm sorry, June 25th, is that correct?
Last week.
And that's set for hearing July 9th. When you were magistrated, given your magisterial warnings, that's Judge McNally back on, what was the date of that? March 12th of 2026. Were you advised that you could communicate with a person protected by the order or a member of the family that you could communicate with them as long as the communication was not a threat?
Correct. I personally asked him and he told me.
Threatening or harassing manner, is that right?
Yes, sir. I personally asked him again after he gave me the paperwork and he said that I was able to see my little girl.
Just the reigning magistrate.
Yes, sir. I don't know his name, but yeah.
Okay. Now, when you bonded out, did the bondsman present you with paperwork that indicated you were to have no contact?
They did, and I brought this to their awareness. And
you say this, you mean the order signed by Judge Durun?
Yes, sir. I brought that to their awareness, and they said that they were going off of what he said.
What the magistrate, what the judge had said, not what you were saying. Is that right?
Correct.
The bondsman. And based upon that understanding, you had communications with him?
My little girl.
Okay. You had communications with her?
Yes, sir.
What about the alleged victim, your wife?
Well, that's how I was getting in contact through her. And whenever child support, I had a hearing with them. They said that they're going to wait for your date of court to come in order for them to give me the rules on what they agreed to. They said they were going to go with what Judge Stevens said.
You talking about CPS or child support?
The child support. So I have a court with them this month as well too. They wanted to see what Judge Stevens was going to say.
Well, we were in court in front of the judge. Judge Stevens personally told you not to have any contact. Is that right? What date do you recall the date?
I think it was the 16th of this month that just passed.
June.
Correct.
June 16th. Since June 16th, have you abided by the court's directive to you not to have any contact?
Haven't had no contact with them ever since.
My past witness.
I have no questions for this witness, Judge.
So let me see your driver's license, please.
Your Honor, can I court defendant's driver's license?
Okay. Thank you. What we got here is just some confusion. Here's the magistrate's order for the emergency protection that was ordered by Judge Durun on December 16th, 2025. You never got a copy of this?
That's my copy right here.
You never.
I got it out of order.
Actually, did you sign this document that states you understand what your obligations were? Yeah, there you go. That's your signature.
This is same, yeah.
It's in blue ink. So you acknowledged on some date, this generally states signed December 16th, but maybe 25, maybe you did or did not on that date, but nonetheless, you signed this order acknowledging receipt of this order, and in this order, it states the court hereby orders you to refrain not to do the following things. You shall not commit family violence against a person protected in this order. Communicating directly with a person protected by this order or a member of the family protected by this order in a threatening or harassing manner. Communicating a threat to any person to a person protected by this order. Going within 100 yards of the residence or place of employment of the business of the person protected by this order. The persons protected by this order or Marissa Cruz, who is yeah. Are y'all still married?
No, sir.
When were you divorced?
We never were married, Your Honor.
You weren't even common law married?
Common law is if you live together a certain amount of time.
And hold yourself out as married.
Yes, sir. Yes, Your Honor.
And then Rosaura Rodriguez is your daughter. Okay, those are the two people who are protected by this order. So what changed subsequent to this? Because this order is in effect and by the judge. And
I think it expired in March, Your Honor, if you look at the order.
oh,
There's an expiration. I was perusing it. I noticed that I believe it's expired in March 12th or something. Just in there.
I don't see these every day.
You see that?
Okay. Is effective until midnight on March. I guess that's 26.
Right.
So after that, are we here on things subsequent to that date?
And then Your Honor, he was served on June 25th with the protective order of family. So now there's this order's in effect. The June 25th.
Well, I don't think I have.
That's not clear, Judge, as far as whether or not we're here on things that happened before or after. That
What are we
March
here
date.
on then? I think the state has a motion to increase the defendant's bond that was filed on June 23rd. And it states that the defendant had not had any contact. This is on June 16th. That the defendant stated he had not had any contact or communication with the victim. On that same day, the victim's mother called the district attorney's office to report he had in fact made repeated communications to her and her daughter and stated he would take them to court to get custody if he was not allowed to see his daughter.
Dr. Lee, I think June 16th, we were in court and the court verbally admonished him not to have any contact. We can go from the 16th.
This state contacted the victim's mother again on June 23rd and was informed that he has been to the house where the victim and her mother lived multiple times and told them he did not have a bond condition where he was not allowed to speak with him. Additionally, the victim's mother stated he has called her multiple times wanting to see his daughter. And then that's the state praised for the granting of a motion to increase the defendant's bond. All right. The problem with this is because I don't know what the times, dates, or events are. It's just generic, and so the court really doesn't have any in the four corners. It's not specific enough, but it does generally allege allegations of wrongdoing, which need to be supported by more evidence than what the four corners state. But the point is what are the orders? And we're going to whatever the orders are that are in effect and might be superseded by other orders. What orders are in effect, but from we got different orders running around from at least 3 different courts now. So mine are important to me, and the ones I give are to be followed. And if he fails to follow after the court's rendition and order goes into effect, then he's subject to.
Obviously, since June 16th and the court's oral admonishment to him and whether or not to have any contact, he's invited that in.
All right. So what can the state say about it?
Judge, I just want to be clear. So I know that paper had no contact in a threatening or harassing manner. Is the court ordering him not to have any contact with the victim or the victim's mom at all?
Yeah. Okay.
That was my understanding.
Yes. Yes. Okay. I want everything frozen until we can resolve this thing as soon as possible. But then what happens is typically is that everybody's got a different story about what the facts are when we're not watching, and then the court's got to resolve the dispute. But the orders, we've got 3 sets of orders here about freezing the action and not having any contact. And
4 if we count the Boston.
And I don't have to remind you about what the four corners of the indictment state. These are very disturbing allegations. So I'm a parent, I'm a grandparent. I can't even fathom even thinking about what these allegations state. I mean, they're very disturbing if they're true. But the grand jury found enough evidence to bring an indictment. So we're going to make sure that whatever evidence they had to support their rendering of an indictment, that is enough for us to freeze the action. And until we can resolve this, I don't want you having any contact, because whatever you do can be, unless we have a jury watching you, it's he said, she said. And I get frustrated with that because that's hard to resolve. But what is easy to order is no contact, nor anyone on your behalf. And get whatever orders we need to be placed in this case until this case can get tried, need to be done. So we've got a family unit that's obviously not a unit, which I know I want a family if it can be put together. If not, then the law will dictate how that will happen. But these are very disturbing allegations. How old is the child, please?
She's turning 2 on September the 27th.
She's going to be 2 years of age?
Correct.
All right, what's the state asking for? Any other relief?
No, sir. We'll refile the motion if needed with better dates. If not, we'll just continue on to the disposition of the case.
Okay, so the orders are you can't have any contact with the child or the mother unless otherwise ordered by the court.
Absolutely.
Your Honor, to be clear, that's direct with your other people. You can't get other people to contact them.
I'm sorry.
It's direct and indirect. You can't get other people to contact them on his behalf.
Yeah, you think
Just to be clear.
acting on your behalf is the same unless it's otherwise approved by the court. Trying to think we're missing something. I don't want something bad to happen here because we had a loose end. Anything else anybody can think about?
Nothing more from
Do
the
we need a
state judge.
GPS device or something on it so we know where he is?
I'll defer to the court, Your Honor.
I would suggest that based on the circumstances surrounding the initial case, Judge, I would suggest that. And the fact that when he was asked about the contact, when he appeared in court the last time, he said no, when there was in fact some contact at some point in time.
Can you explain that?
I think so.
Can you explain that?
Well, Your Honor, I was.
Why weren't you forthright with me?
I was asked if I was living with them, and I said no, I wasn't living with them. And I was basically going off of the other paper that I received from whenever I got out of the county. But ever since you mentioned that, no contact. And on my work of mine too, I do go see people on a daily basis. And I don't know, that monitor, I mean, shorts, I don't know if that's going to be looking real presentable on my end.
You know what? I couldn't care less.
I understand.
That's not my concern. You put yourself in the situation.
I understand.
Okay. Well, you're going to have to, it's not going to be as convenient as it would have otherwise been had we not been in this situation with these allegations.
Correct.
But yeah, that's if I order a GPS, then that's your problem. You have to deal with it. We got a lot of people running around GPS in this court, out of this court, and they function. But once again, those are problems that occur that have to be dealt with, that the court has to respond to ensure that the status quo is kept until we can resolve this. If I find out about it, I'm gonna, I don't think, number one, and one other thing that bothers me is what they're saying is in this probable cause affidavit, this occurred while you were apparently intoxicated. What about that?
I shouldn't drink or consume intoxicating substances as well, Your Honor. No alcohol.
Yeah. Obviously, that may have, which is not an excuse under the law, but I see it all the time. And people, well, I was intoxicated. Unless somebody forced it down your throat, you are responsible for your actions. All right, what's the next event?
He had refused to please a straight probation officer. We wanted deferred, so I've set it on the trial document, I guess. I'm not sure at this stage that the kind of believe it unagreed. I mean, I'd like him, if I'm going to do that, to establish a track record on his part that he can abide by the court's conditions while on bond. So in order to have a better argument, if I do go unagreed to the court, that you should get him deferred instead of straight or the state's objection. That's where I am with it.
Mm-hmm.
He doesn't have any criminal history. No, he has significant criminal history. He's eligible for jury probation. Of course, that would be with a conviction. But the state's not offering deferred at this point.
What's up, man? You need me, man? Hey, I told you.
So if I am going to go to the court and ask for deferred, I'd like him to have a track record. He can abide by these conditions and then what's required of him for the court to consider that, making its determination of whether he should get deferred or not.
And just to correct,
Here's the problem. Go ahead.
I'm sorry.
just to correct for the court, defense counsel just made a statement that he doesn't have any criminal history.
Significant criminal
Okay,
history.
he does have a couple possession of controlled substance and I believe an unlawful carrying of a weapon.
No felony. That's a significant criminal history, Mr. Quality.
Just aside here, why don't y'all look legally at the indictment? What it states is under this indictment, is he eligible for regular probation in front of a jury? I don't think so, because it says a firearm was used in the commission of the crime.
So the jury couldn't give him probation?
I think so.
Okay. On the 3G? I thought they could. I'll have to review that.
Well, I think that needs to get looked at.
Yeah, that changes the perspective of investigation.
All right, let's.
I still would like to have him out for a while if I'm going to go to the court.
Sorry?
I would like him to be out on bond to establish that we can abide by the court's conditions with one attempt to get the court to get him deferred.
What else do we have? What orders are you asking right now from this court?
The GPS, the no alcohol or drugs, and the no contact.
All right, I don't see that that's unreasonable. I'm going to order that. You got 24 hours to get all that done. Go through him. He knows how to do it. So two of those are things that are going to be your decisions in your actions. The other, you have to have a GPS device so that if there is ever an issue, I wasn't there. Yes, I was. No, yes, he was. No, he wasn't. And the GPS will monitor your whereabouts. And again, no contact with the mother or the child until further orders. Anything else? And what do we do? Our next event is what, trial? Is that what you want?
Well, just set for that.
Sir.
Set for now.
All right. How long?
I think it's.
What do you want? 4 or 6 weeks?
6 weeks. That's fine.
6 weeks. Thank you. Okay. That is all. Please get resetting. Thank you. Braden Charlo, Langston. That you're breaking it?
Yes, sir. Come on up, Mr. Hall. He's there.
Okay, it's 26 CR 903.
Yes, sir.
That you?
Yes.
You were charged here with harassment of a public servant, which is, if convicted of third-degree felony, you were looking at no less than 2 nor more than 10 years confinement in prison, and the fine up to $10,000 can be assessed. Do you understand the punishment range that is applicable if found guilty here?
Yes, sir, Your Honor.
It's the last one. New possession of controlled substance. And she asked her last night, so she's currently with vegetability.
What's the relationship with the complainant here and the defendant?
As of right now, Mr.
What's the relationship? Langston? What is the?
Oh,
Was a police officer.
it's a police officer. It's not, this is
Harassment of a public servant.
service. It's the
It
police.
says the complainant additionally advised that
The lady,
was attempting to force entry into her residence by kicking the door in.
she's not complaining at all. I think police officer saying he was spit.
Upon arrival, officers observed the complainant, Caden Branch,
Well, it was no,
and Charlo in the front door. I mean, this probable cause talks about a complainant.
right, but I'm
Branch said that Charlo pulled a knife on her and wanted him removed for her property.
right, but
Then the officers were investigating, and he becomes uncooperative and begins to walk backwards. Officers grabbed a hold of him. He began to physically arrest. Then he was handcuffed and, let's see, turned in the direction of officer and spat on her. While a search was going to be conducted in front of the police vehicle, he caused someone he knew to be a public servant to come in contact with saliva while the public servant was lawfully discharging an official duty. Also, apparently the defendant grabbed Caden Branch by the shirt and threatened to kill her while having a knife in his hand. Branch advised that he had left the residence, but he returned shortly after, and that's when he kicked the door in and police were contacted. Branch wanted to pursue criminal charges. Charlo was placed under arrest for assault, family violence with deadly weapon, and harassment of his public servant.
Judge, I'm not sure why I don't have the ag assault case. I only have the harassment of a public servant.
I'm over here for that harassment.
Okay. Today, what is this for today?
This is our first sitting, Judge. We want to put it on the announcement.
Okay. Couple of things. Orders are going to be entered to have no contact, nor anyone on your behalf contact the complainant who is the officer, nor the person Miss Branch, the person that the police came out to investigate you and your bizarre behavior that day. And you're going to have a GPS device, so I know where you are. So if you get any contact with her, I'll know about it and place you in jail. And that's where you will stay.
Can I say something,
Go ahead.
Me and her are actually still friends.
No. Friends don't act this way.
No, like we
kind of like stated against me.
I don't care. Friends don't act this way. She called the police.
Yeah, she dropped the charge.
I don't care. She called the police.
Yeah, she's.
You, unless she lied to the police, and then we'll bring her up here. And then that's a crime. I want to know. She apparently was not lying when you acted the way you did this night, not only spitting on the officer, but pulling a knife on your friend. And attempting to force entry into her residence by kicking the door in. Don't have any contact. She's going to be a witness in this case. That supersedes any.
Even if she
attempted to try to change her story.
I was in a county on both the charges.
I don't care. You're under my jurisdiction right now.
Yes.
You're going to follow the rules and not act foolish. You're going to have a GPS device so I know where you are, have no contact with this witness, and no contact with the officer as well. You understand? That's a yes? Okay, nodding doesn't get it on the record. You have to speak. That's the way we communicate. You understand?
Yes, sir.
Your problem is you're not following the rules. You're looking at up to 10 years in prison. Does that bother you? Does that worry you at all?
Yes.
It should. It should. All right, what's my next event? Announcement?
Yes, sir.
You have 48 hours to get the GPS device. And those are the orders of the court. That is all. This quarterly cornish.
I started on. No, I'm here. Just take on. We'll bring it back when you're done. But hey,
Quarterly cornish.
forward that. I'm sorry. But hey.
Is this an initial? No, it's an announcement.
This is an announcement. We did do discovery on this case.
Yeah.
And in talking, and the state's offered.
Ooh, God, dog, it's 2 years old, almost.
Right. And we looked at police reports. Ms. Cornish is informed me that she's absolutely innocent.
Yes, Ron.
That's what the presumption is all about. Well, I tell you, if I could just get a case here where extreme intoxication wasn't part of the actions, I jump off a cliff because that's what this is over and over again. Everybody's intoxicated. And here's my favorite thing. You're driving a car. Y'all are both intoxicated and in a vehicle, a 4,000-pound missile. It's great. Yeah, I know you're smiling, but you know what? You know what we deal with in here? People who have been struck and killed by fatal incidents by drunk drivers. And there's no laughing. It's all a bunch of crying and sobbing and people begging to get their loved ones brought back. You ought to just sit in here and watch that. You wouldn't smile. Cornish wrecked. So you wrecked the car, her car, and not wrecked it into any other kind of vehicle, but into a patrol unit. Inviter, which the unit was working erect, and you were obviously so inebriated you didn't know what you were doing.
Oh, you're in the. I have a lot.
The complainant says you drove her car without permission and wished to file charges, and she got her wish. Here we are. Here's my favorite thing. I'm going to look into whether you've had any contact with this person. If you do, you'll sit it out in jail. You cannot contact a witness while this is pending. And these facts, I mean, I've do this for a long time. You look too confident about all of this because you think you've already worked it out on the side. We all know that because we see it attempted all the time here. What happens is all it does is bring more charges to you. And the court's not going to allow that. I'll order the people to show up and we'll have a trial and they'll testify under oath and they can either tell the truth or they can lie and then they get in trouble. But here, a very serious event occurred and we're lucky people weren't killed because of reckless behavior. Not only driving someone else's car unauthorized, but slamming into a police vehicle that was investigating some kind of other incident on the road. All right, we'll set this for trial. Now get ready. And by the way, a jury doesn't give deferred. If you're found guilty and even if you're given probation, it's a conviction for the rest of your life.
Yes, Your Honor.
Christopher Price?
He's here.
Christopher Price, what are we doing?
This is our first appearance. Initial set with him. It's the first time I did get discovery.
Okay, what do we? You're charged with state jail felony.
Yes, sir.
Oh boy, solicitation of prostitution. That's never a good one. This carries with it up to 2 years in the state jail. I don't see a prior conviction here. A prior conviction. You've never been convicted before. Fix this.
Yes, sir.
No, it worked with him. Who knows? What are we going to do today?
Just the plan is I was going to send a letter to Mr. Canard asking for a pretrial diversion and see what he says. And in the meantime, just put it on my notes.
Okay, I'm sending an answer for him. Okay. Mario, just getting resetting it. Mario Senegal.
The Senegal?
Senegal.
She's here.
State. Okay. That's you, the Senegal. Come on up.
Same thing with her, Judge. This is.
I don't see any prior convictions here either, huh?
Correct. And this
you've never been convicted before. Okay. Fix this. Fix it.
I can ask for the same thing for her. And this is her first sitting for you as well.
Again, like the man before you, you're charged with a state jail felony, which carries with it up to 2 years in the state jail, but it's a felony. If you're convicted of a felony, it's with you like a horse riding on your back for the rest of your life. Closes off doors of opportunity, and it prevents you from enjoying some blessings of liberty because that conviction follows you forever. Fix it.
Yes, sir.
He knows how. Mm-hmm. All right, let's reset as well for an announcement. Ashley Stevens was reset.
Ashley Stevens is reset?
Yes.
He was arrested last night, so currently with Judge McNally in the rain for
Sean Thomas.
He's here. I think you had set this one for a special. I don't know. It was a special.
I don't know. Oh.
I think I
know. He's testing positive for cocaine.
Yes, sir. I just talked to Johnny today. And
positive for cocaine. Hold on. Positive for cocaine. Positive for cocaine. Positive for cocaine 5 different times. Where are you getting it from?
So it's my barber. I went to my barber today. I cut my hair.
You said that again?
My barber. Did you do my hair?
Yeah.
I guess he has it on his hands.
Oh, he has it on his hands. How long have you been working on that one? It's a mystical event here.
Oh, sorry.
We've got you really think that hadn't been tried before? And if that worked, don't you think everybody would pull that one? Oh, I get it from my barber. Who is your barber that has cocaine? What's his name?
His name's Stephen.
What's his last name? It's your barber. What's his name?
Stephen Giles.
Okay. So where's he getting the cocaine from if it's coming from him? Do you know?
No, sir.
Well, how do you know he's got the cocaine?
I just seen
the first name you could think of to blame?
I seen it on his hand. I seen it on his hands the last time.
How do you know that was cocaine and not other powder?
I just seen like white residue.
Oh, okay, it's powder. They use that at a barbershop.
I know I don't do it, so.
Okay, well, they use that at a barbershop. Generally, they don't use cocaine.
It's not a professional barber.
Okay, I don't care what it is. They still use powder. I mean, that's what it normally is. But hey, you chose the guy.
Yeah.
You chose the guy. You've been testing positive since. It's insane. Right. About every 2 weeks, you're testing positive. How often are you going to the barber? You're going to the barber every 2 weeks?
Yes.
Yeah. Okay. Nonetheless, this is all.
I talked to Giants too the last time, and she said it might not.
What's his bond right now?
You heard me, sir?
I heard you. Did you hear me?
Yes.
What's his bond?
I'm looking.
You don't run things here. You're charged with a serious crime. You're looking at 2 years in prison, and you've tested 5 times for felony offenses. You might want to stay quiet.
$20,000.
That's not enough. It's $100,000. Plus, you have to have a drug patch. 24 hours. That's right. That's how we're testing it. Well, the drug patch is not working. Next positive drug, you're revoked, but you've got 100,000 now. Taken into custody until you can make that.
It's $100,000.
It's $100,000, and the next positive will be no bond. We'll work with you here to try to get you off your problem. What are we going to do next? What are we going to do next?
I guess at this point we can put on an announcement. I can get with him to see, because I'm now what he did tell me, and maybe this might be somewhat of a help to him, is that if you look at the date of the last test, it says 5/29/26.
Yeah.
And he told, though, and to my understanding, is that on May the, I want to say you said 14th, on May the 14th or 15th, somewhere on there, is when he had his prior, test for being positive. And when you take this test on the 29th, that's still within that 14-day window, and the cocaine doesn't leave.
It's a 15-day wait.
Well, I'm sorry.
14 29 is 15 days.
Well, 14, I'm trying to stay within.
I know, but no science has ever shown that. I mean, it's about a 2-week window.
Yeah.
But nonetheless, this is spanned over how many months? 3? Come on. Cocaine moves out of your system fast. We all know that. That's what it's called, speed. All right, those are the orders on the board. That is all. Thank you. Hey, Langston, on
which one?
You got, is that it? You don't have.
I think that's
okay. All right.
That's it.
Edwin Jones. What are you doing, Dustin, on Benjamin Figueroa?
Well, Judge, it's my understanding, we're just here for review. My understanding, he's still doing great. I asked the probation officer, and she said he's had no issues since the last time we were here. This is one we have been respect for a long time because he had for restitution. He's paid that all. But there's a new case coming, and that's what we've been waiting on as well. So we're just kind of holding back.
What are we supposed to, it says a hearing. What are we supposed to do?
I don't think we're really set up hearing. We've been here several times. But Judge, I believe we
revoking probation filed, right?
Yeah, but I believe Mr. Coleman took the checks over.
Why are we having a motion to revoke probation hearing anytime?
Well, one reason, Judge, is because they have not received the new DWI. But the other reason was because there was a large amount of restitution, and the court reset this several times for him to make payments, and he paid all of that off. And so there's kind of two things going on, but we still don't have the new case, and he has paid all the restitution on
it. Okay, this was filed back in September of last year. This is too long. for a motion. We're going to move forward without the driving. If whatever we're waiting on the DWI, forget it. I've got 3 other violations set for hearing. When can y'all be ready?
A couple weeks, Judge. I know that Mr.
2
Coleman
weeks.
was appointed to it. I know Mr. Coleman just recently received it. He's not familiar with it.
weeks to get ready. Means I sold 2 weeks.
What's 2 weeks right now?
14 days. Yes. Okay, and get a resetting, 2 weeks for hearing. Edwin Jones, where's Mr. Jones? That's you. Wait. Where's Benjamin Figueroa?
He's right there on the back row.
Okay, he needs to come up and get a resetting. Okay, Thomas Burbank is where is he?
I think he's in trial next door. Huh?
I saw him walking in the drug impact court when I drove in.
He had to go to drug impact for this morning and then.
He's in trial next door?
Yes.
So what were we supposed to do today? Did he leave an announcement or anything?
Not with me, Judge. Just a bit.
Good Lord. It's 5 years old. I was a teenager when this thing was filed. Almost. That's correct. This is. Good Lord. No. Good grief. Set for trial. Put it on the trial docket as soon as possible. We need relief here, all of us.
Yes, sir.
You know, I don't see any prior convictions. Have you ever been convicted of anything?
No, sir, I don't get in trouble.
Mr. Parker.
Do I have,
He signed on your spot on one of the plates. I'm just fixing it.
in both cases or just one?
Just one.
He's putting on both cases. He signed.
You just signed one spot.
Oh, because I don't see any here yet.
Yes.
Okay.
Listen.
Right, sir, are you Marvin Lee Watts
Julie.
Jr.? And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Absolutely.
Mr. Watson, cause number 25, DCCR 1918. You're charged with the first-degree felony offense of aggravated robbery from October 2nd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then in clause number 26, DCCR 0946, you're also charged with a first-degree felony offense of aggravated robbery. This is from September 12th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In each of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney's office, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each of your cases is for a cap of 17 years in prison, which means you're leaving your punishment up to me. I can give you 17 years. I can give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have every right to have a jury come in and decide 2 things. First, to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that. And is that what you want to do? So you have, what you've agreed to is a cap of 17 years, which means a cap, all that means is that you're leaving your punishment up to me. And you could, if you wanted, have a jury decide instead of me. But if we go forward this way with the papers that you've signed that says that you're waiving a jury and that you want me to sentence you within that range of punishment, which would be between 5 years up to 17 years, there's the possibility of probation. It'll all, again, depend on what information I get when we come back for sentencing. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Watts is not competent?
Second.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases for when we come back for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Parker. He'll present it to me on your behalf. Okay.
Yes.
Right. You can go back with the baby.
Judge, thanks for getting me in.
Yes, sir.
Your Honor.
Mr. Macon, you have Cyprian Avedontu. Yeah,
That's what, Your Honor.
it's not even close, I'm sure, but Avedonute?
Romania. What's the name, Judge?
Cyprian Avedonute.
You got it.
You didn't want to relay that? Good morning. Good morning.
How you doing?
Welcome. That's I just realized now that I'm reading on, I'm noticing that they're backwards. What's that? No, they changed it and she's getting it changed back. Yeah. Good morning.
Good morning.
And are you Cyprian? Is it Avedad Natue?
Yes.
Close enough. All right. And Mr. Avedad Natue, I can't say it. Is charged with unlawful interception or use of a wire oral electronic communication. And Mr. Macon, what is the announcement?
Yeah, and I'm going to call him Cyprian. He just got back here from California. He was in custody out there and they brought him back. And Pam was just appointed on the case. And I really haven't got with her to discuss all the things. Plus, I have a Romanian interpreter interpreting quite a few papers that show my client was out of the country. But I would ask for a normal resetting.
Okay.
I'd work on all that.
All right. And Ms. French, any issues with the
No,
reset?
I've been given a thumb drive with information on it, and I'll be reviewing that as well. So I appreciate the reset.
All right, we'll just do a normal reset and then we'll see where we get the next court date. You can go back with the bailiff. Mr. Kelly, you've got Dalton Batiste.
Judge, that's Mr. Coleman told on that case. Can you hold it just for a minute? He knows Mr. Kelly's here.
Sure.
He's gonna come up. Thank you.
Thanks. Not yet, I'm sorry.
All right. Not at all. Thank you very much. Thank you very much. Very well.
See, Mr. Lewis, you've got DeJuan Banks.
Yes, ma'am.
DeJuan Banks.
Right.
No. It just was.
How are you, Mr. Lewis?
I'm doing all right.
Good. Good morning. Are you DeJuan Banks?
Yes.
And Mr. Banks, in cause number 25 DCCR 0990 is charged with injury to a child, elderly, or disabled individual. What is the announcement?
Well, Judge, when last setting he was here, I think it was some issues where the state was trying to locate where exactly what placement where the child was, so we try to move this case along. We have since found that information out recently. He is out of state. So I know now they're
Judge, if it makes sense to you, and Mr. Lewis has been nothing but helpful to me. And we have talked about different offers that one would expect would resolve the case if guilt was really on Mr. Batiste. What I'm trying to do is find Banks. Sorry, I'm sorry. I'm 30 seconds behind. Sorry about that. If that makes sense what I'm saying without saying it out loud. The child is in the custody of family members under the care of foster care. So when I look from everything I have access to, it looks as if the child is in the care of foster care, which is where I have been going to try to locate people to speak with. But now the child is in foster care, but with the family, if that makes sense. And I wouldn't know this information but for Mr. Lewis, which is now who I need to speak with. I know it says final. If we need to put it on the trial market, obviously that will be done well in advance of when that trial market would be. That's
No, I guess you're saying you now have, where you.
Yes. Okay. Even though all the logistics say foster care, the child is still in foster care, but is with the grandparent.
I'm going to do one more reset to give you some time to get, visit with them, and then let's get an announcement at the next.
And they have been generous with that information. Otherwise, I wouldn't know where that child is other than through the foster care system. That he's not a possessor of custody.
Okay. Speak. All right. Thank you. You can go back with the bailiff.
Thanks.
Thelma Gilbert.
Gilbert.
Good morning. Are you Thelma Gilbert? Answer out loud, please. And this is cause numbers 26 DCCR 0502, 03, 04, 05, 06, 07, and 08. Ms. Gilbert is charged with credit or debit card abuse in 4 of those cases, burglary of a habitation in a case, fraudulent use or possession of identifying information, as well as theft of property. And what is the announcement?
Judge, we've gotten a offer that will probably resolve this matter. It's going to involve a lengthy prison sentence. Our issue right now is day before yesterday, Ms. Gilbert's daughter and her father were involved in an auto accident and they're being hospitalized in Dallas. So we're trying to find out, I guess that's exactly what's going on with them. So she'll know basically the stability of her daughter before we do the agreement. So I'm just asking for short settings so we can get that resolved so we can move this case along, Judge.
I told Mr. Lewis I would hold that offer open if we got to reset for that reason at 89.
All right, I'll reset it one time for that.
Thank you, Judge.
You can go back with the bailiff. Thank you. Fan, Mr. Lewis?
Hold on that one.
Sure. Thank you. We'll hold that.
Hold on, I'm saying.
That one, we're done. Justin Thomas, Mr. Lewis. Competency.
Yes,
He's confident now.
yeah, we just got it back.
Okay, so you'll just need some time.
Yes, ma'am.
Let me make this finding of competency and then
And I need to look into some kind of way while he was in the hospital there. I think he got a PR bond on one of the cases. I'm just trying to maybe check, see where that even came from. He gave me the paper system.
Kelly, can you make a note to look into that? Yeah, please. All right, sir, you Justin Thomas? And I'm going to take judicial notice of the court's files and cause numbers 25 DCCR 0308 and 25 DCCR 1874. Mr. Thomas was previously found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for Competency Restoration. I've received that report dated June 16th of 2026. It includes the trial competency evaluation report, which is prepared by Dr. Guzman. The findings in that report is that he is currently competent, has achieved competency while he was there. Also in that packet is the attending physician's report to the court, and that is dated June 15th of 2026, prepared by Dr. Liberis, again with the finding that Mr. Thomas has achieved competency and is currently competent to stand trial. Is there anything else with regard to competency? Then at this time, I am going to find that Mr. Thomas is competent to stand trial. My understanding is he just got back here from John Dunn, and so I'm going to do a normal reset. That'll give you some time to visit with Mr. Thomas about any options he has on his case. All right, so Mr. Thomas, Mr. Lewis will be out to see you very soon to go over everything with you, okay? All right, we can go back with the bailiff.
Thank you.
And then you've got Jason Weinberg. It's the sentencing.
That's right. Weinberg. Weinberg.
Smart for that. Yes.
Good morning. You're Jason Weinberg?
Yes.
And Mr. Weinberg was previously here and entered a plea of guilty in clause number 25 DCCR 1479 to the state jail felony offense of engaging in organized criminal activity. I've received that pre-sentence report. Have you both had an opportunity to review the report?
Yes, Your Honor, we have.
Any additions or corrections?
No,
Not from the state, Your Honor.
All right, Mr. Weinberg, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings. You'll be placed on probation for 5 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation.
Yes.
If you do that, this is a great opportunity. You're very young. You don't have a felony conviction on your record. And if you successfully complete this probation, you'll never have a felony conviction. At the end, the case gets dismissed. It's a great opportunity. The other side of that, though, is if you violate any condition of probation, you can be back here in court, found guilty, so you become a convicted felon, and you can go to the state jail prison for up to 2 years. Understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. Probation will talk to you probably before you leave. Good luck to you, sir.
Thank you.
All right.
Thank you, Your Honor.
Thanks.
I'm sorry. No, that was, we'll see. Since it's a state jail, she said no ISF for him. I said, no, we'll hopefully not need that. Not too bad. So, that DeMarcus Evelyn is going to be Brittany handling that. Yes. And that's for a bond. Yes. Okay. Good morning.
I'm County, so Tom, I can do a cooking song. I'm just going to take on the back.
That is on Dalton Beach. Okay.
And congratulations.
I know. Thank you.
Y'all have a great day.
Thank you too. Let's see. I know, usually he at least stops by. Ms. Holmes, are you ready on Daniel Eli?
You may be a pro on.
Audubon's supposed to plea him. Audubon has his misdemeanor.
Oh, okay.
He's supposed to plea on the misdemeanor so that will dispose of the felony.
Okay.
Can't find Audubon.
Okay. Well, I'll hold it.
Okay.
Is he supposed to do it today?
Yeah.
Yes, they've always been set together.
Yeah.
It's been trying to get it all of the parties here.
Okay.
And if
I'll hold it. And
push comes, Judge, I can do that today. Well, if you allow me to put on the record, then if that does not.
that's well, and that's fine if we need, I mean, I can just reset it a week and then get them down there this week, but
Yeah,
maybe,
it just keeps going back and forth.
yeah.
Unless they let me plea him. So if it's Audubon's, if they let step in and plea him, they press the banner.
See if you can get, y'all already tried to call Audubon this morning.
I have not.
See if y'all can get him on the phone, and if he's around, great. If not, see if he'll give you permission to do that.
Okay.
I'll hold it for now, though.
Oh.
And then you got Janaea Fine.
Yes, sir. Please.
Yeah, that's the other one.
At one, she should make another copy of.
Oh, okay. Thank you. Today's this. Good morning. Are you Janaea Fine?
Yes, ma'am. Yes, Your Honor.
And will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Ms. Fine, in clause number 26, DCCR 0432, you're charged with a second-degree felony offense of assault on a peace officer from January 13th of 2026. And how do you plead to that charge?
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
And then we have clause number 26 DCCR 0433. And in that case, you're charged with a third-degree felony offense of harassment of a public servant. And that's from January 13th of 2026. And how do you plead to that charge?
I plead guilty.
And are you also pleading guilty in that case freely and voluntarily?
Yes, Your Honor.
And because you did what they charged you with?
Yes, Your Honor.
In both of those cases, I have here on the tablet some documents that have your signature on them, but the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached in each of your cases is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Fine is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. Before we talk about the bond, there is only a fine in 0432 of $500. There's no fine in 0433. And so, Ms. Malfino, what's the state's position with regard to a bond? So, Ms. Fine, what I'm going to do in each of your cases, based on the nature of your plea agreements, is reduce your bond in each case to $1,000. I'm going to make those personal bonds, which means you don't even have to pay any money. You're just going to get released from jail today. But there's some very, very important things that have to happen between now and when you come back for sentencing if you want me to go along with this deal. The first thing is that when you are released from custody, the very first thing you do is go to the probation department. You're going to get some papers today. It's going to tell you where to go. So you have to go straight there so they can start that process to get that report from you. Okay.
Yes, Your Honor.
If you don't do that, then obviously a warrant could go out for your arrest. I don't have to follow this agreement. Things can be a whole lot worse. So it's very important that you do that. Okay.
As long as the address on it, Your Honor, I'll go.
The address will be on it. You'll talk to a probation officer in the courtroom today before you leave, and she'll tell you everything you need to know about where to go. Okay. The next thing is that you cannot get in any trouble or arrested for anything between now and when you come back. If you get arrested for anything, you run the risk of me raising your bond, or you'd be back in here and I don't have to follow this agreement. You understand?
Yes, Your Honor.
All right. You can go back with the bailiff. We'll see you at sentencing. Anthony James. Ms. Holmes?
You can hold that one.
Sure. And then what about Michael Spain?
To test it.
All right, so you're Dalton Batiste. Answer out loud, please. And this is clause numbers 25 DCCR 1436, 1437. In each of those cases, Mr. Batiste is charged with manslaughter. And then in 24 DCCR 0407, charged with possession of marijuana. And what is the announcement?
Send objections to the court, Judge.
Go through that. Sorry, I didn't. All right. So, Mr. Batiste, in each of those manslaughter cases, the range of punishment, if you're found guilty by a jury, that's the state jail. Sorry, I had the wrong one pulled up. 4 seconds, correct?
Yes, yes, Judge.
Is between 2 years and up to 20 years in prison in each of those cases. And then in that possession of marijuana case, if you're found guilty by a jury, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yeah, yes.
And I have here on the tablet some plea bargain rejections that you've signed with Mr. Kelly that shows that the district attorney's office has made offers if you wanted to enter plea of guilty for 10-year term in the manslaughter cases.
I don't think we sent a third one, Judge. We didn't.
With, I guess, something on that state jail that would run concurrently with that. So it would be 2 10-year sentences, but they would run at the same time. And then whatever you got on the state jail would also run concurrently or at the same time. You have every right to reject those offers and have all of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject those offers and have all of your cases set for trial?
Sure.
All right, we'll get them set on the trial docket, and Mr. Kelly and Mr. Gertz will get them in preparation for trial. You can go back with the bailiff. Thank you. Yep.
Those actually, they're prior that it is, that's the first, I'll be.
Did they?
They're in the indictment.
Dalton Batiste. Guess Tom's already gone.
They went back to.
Would you grab Tom real quick? I'm trying to make sure. Would you send me back one of the rejections?
It's in the indictment.
Did you go over with him, the enhancement at first? You've gone over that and explained. I think since I didn't do it on the record, I want to make sure that's been done. Okay, perfect. Thank you. No, ma'am, I'm good. Mr. Rojas, you've got Jamon Adams.
Actually,
Yes. Good morning. Are you Jamon Adams?
Yes, ma'am.
And Mr. Adams, in cause number 26, DCCR 0744, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. And that's from April 7th of 2026. And what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that you signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Adams, Mr. Rojas is your court-appointed attorney at this point, and he's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Rojas, be released. We'll appoint someone today. They should be out to see you very soon to begin preparation for trial.
Okay.
All right, you can go back with the bailiff.
Can I ask you a question?
You sure?
When it comes to the next lawyer, will I be able to tell you what really happened? Because the last time I heard.
So you just need to talk to your lawyer about that.
Okay.
That's who you need to tell everything. And then he'll talk to the district attorney, and that's all kind of between you guys, not necessarily me, okay?
Yes, ma'am.
All right, you can go back to the bailiff. Linton Alexander.
Linton Alexander.
Good morning. Are you Linton Alexander?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Alexander, in cause number 26 DCCR 0601, the state has elected to proceed on the lesser offense of a third-degree felony attempted burglary of a habitation from March 12th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Alexander is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of attempted burglary of a habitation, sentence you in accordance with your agreement to a term of 5 years in the institutional division.
Should be 4, Judge. Judge, I think, I know it originally was 5. Maybe Mr. Ross accidentally wrote 5. We talked about it when I reduced it because the offer was 4. It should have been 4 the whole time. If I didn't catch it, that's on me.
It says 5.
It's 4.
I'll
Sorry,
check.
Judge. It's supposed to be.
That's okay.
Turn you. It's cool.
Hold on, let me, with everybody's permission, I can change.
Still catching.
All right, so I'm going to sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Rojas.
Okay.
All right. Good luck to you, sir. You can go back with the Bailey.
Thank you, Your Honor.
Thank you. Justice Larzo. Oh, yeah, okay, thank you. And it's just, we don't have anything done or, yeah, we're just gonna. Good morning, are you Justice Larzo?
Yes, ma'am.
And Mr. Larzo, in cause number 26 DCCR 0770, you're charged with the third-degree felony offense of obstruction or retaliation from March 8th of 2026. Your indictment alleges that you were previously convicted of assault on a peace officer and assault on a public servant on October 12th of 2023, both of those cases on the same day, which means if you go to trial and are found guilty in these cases, or this case, and those prior offenses are true, that means you would be considered a second-degree felony for punishment, which is between 2 years up to 20 years in prison. Do you understand all of that?
You can repeat that, ma'am?
What part of it do you not understand?
The first part.
What you're charged with?
The part where you said.
So here's the thing. You're charged with obstruction or retaliation.
Correct.
The offense date is March 8th of 2026.
Correct.
And that's a third-degree felony.
Correct.
The indictment also shows me that you were already convicted of 2 other felonies on the same day. What that means is if those are true, or at least one of them is true, it would enhance your punishment in this case to a second-degree felony, which means if you go to trial, you're found guilty, the range of punishment is between 2 years and up to 20 years instead of 2 to 10. Do you understand?
Yes.
Sure.
What it says is if you convicted, if you catch the case, two of the cases at the same time, then that would be consist of the enhancements. If you put both of those charges at the same time, I didn't catch those charges at the same time, even though I was convicted at the same time because they ran a CC.
Here's the thing, it only matters on one of them, right? Because the fact that they were run CC is what makes this enhanced by one instead of turning it into a habitual. So I'm only counting it like it's one, right? So let's just assume you have one prior conviction. It doesn't matter if you have 1 or 2 or 14 from the same day, the same conviction day. It only will enhance this one level, which means from a 3rd degree to a 2nd degree, just like I said. Make sense? Okay, so.
I'm sorry to interrupt,
Sure.
if I may.
Yes.
The benefit of the defendant, I've tendered that pen pack to Mr. Rojas. The convictions are on the same day, but for the actual same type of offense. And in this instance, he threatened to murder a police officer, which is why the offer is what it is. And for his benefit, I also tend to introduce a punishment where available by the rules of evidence, the misdemeanor and juvenile contacts with the law that he has had as well.
All right. Thank you, Ms. Malfino. So you've had an opportunity to visit with Mr. Rojas about your case. And Mr. Rojas, do y'all have an announcement?
Judge, I was speaking with Mr. Larzer yesterday. I think his intention is to come here this morning and ask for a new lawyer. I explained to him the way to get a new lawyer is to reject the offer and set it for trial, because I think that was originally his intention. He, however, didn't want to sign any paperwork with me.
Because I haven't got an offer. You haven't gave me an offer. You said 5-year cap. I don't know what that is. That's not offer. If you offer me 5 years TDC or you offer me 5 years probation, you can say which one. So when I get an offer, I'll let you know. I don't know what the offer is.
Sounds like the offer was a 5-year cap. Is that correct,
That's the
Mr.
offer.
Rojas? And I'm sure Mr. Rojas explained to you what a cap is.
Yeah, he just said I can't get more than 5 years.
Right.
Okay, so what is the offer? How many years? 5 years TDC?
So it's up to me. So if you sign for a cap, and I'm sure Mr. Rojas explained this to you, it's a way for you to try to come to me and say, give me less than 5. I could give you 5, 4, 3, 2, or I could consider probation. It would all depend on the information that I received at a sentencing hearing. But if I follow the agreement, I couldn't give you more than 5. So it's something where it's not for sure. You have an opportunity to ask for something within that range. Does that?
Tell me this today.
What?
I would like to take care of this today.
Well, talk to your attorney and listen to what he has to say. And if y'all want to take care of it today, then there's some paperwork that you have to go over with and sign, and then we'll go forward. All right? You can go back with the bailiff. Joey Mink.
Joey Mink.
Paperwork on this one. Oh, I don't have it yet. All
yeah, that's there. Not for your sake, husband.
Good morning. Are you Joey Mink?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion in each case?
He will, Your Honor.
I'm going to need.
And Judge, I'm going to give you a heads up on this. The motions were, you're going to shake your head if they don't match up, or if they've been administratively difficult, for lack of a better.
Let me get them printed out real quick, and we can all be.
At one point in time, the probation department only wanted 1 filed, and then the clerk asked why there wasn't 2 filed, brought that to my attention. So I filed the second one. So if there's errors, I apologize in advance.
So we'll just start with the first one. There's Mr. Mink in cause number, and he'll waive the formal reading in both.
He will.
Okay. So Mr. Mink, in cause number 23 DCCR 1851, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for the 3rd degree felony offense of evading arrest or detention with the use of the vehicle. And that was a 4-year deferred probation. Is that correct? And in cause number 24, DCCR 0294, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for aggravated assault with a deadly weapon, a second-degree felony, and that was a 6-year deferred probation. Is that correct? Both of these cases allege that you violated your probation. Count 1 in each case alleges that you violated the special amendment requiring you to successfully re-enter the SafeP program. And is that true or not true? True or not true? And then in cause number 24 DCCR 0294, that motion also alleges in count 2 that you failed to provide verification of performing the community services required. Is that true or not true? True. And count 3 in that case alleges that you're behind in your court assessed fees. Is that true or not true? Did you enter your pleas of true to all of those counts freely and voluntarily? And did you plead true to them because they were actually true? In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal? State tenders number 1 in each case?
No objection, Your Honor.
It's admitted in each case. And is the punishment the same?
Yeah.
Okay. All right. I'm going to find in each of your cases that you entered your pleas of pleas of true to counts 1 in the one case and then 1, 2, and 3 in the other, freely and voluntarily. Find all of those counts true. In cause number 23, DCCR 1851, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a motor vehicle. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 0294, find counts 1, 2, and 3 true, find sufficient evidence in that case to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon in that case. The 2 cases or the 2 sentences will run concurrently, which means together at the same time. I'm going to hand you in each case the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right. Good luck to you, sir. You can go back with the bailiff. Okay. Just that one? Yes, one. Thank you. Let's see, Kashonda Riley to sentencing. Morning.
Good morning.
Right, ma'am, are you Kashonda Riley?
Yes, ma'am.
And so we've got 3 cases here for sentencing. Cause number 24 DCCR 1778 is a motion to revoke probation. Ms. Riley is on probation for theft of property with previous convictions. Entered pleas of true in that case. Let's see which counts.
I believe 1 through 5.
1 through 5, thank you. And then we've got 2 new cases, 26 DCCR 0210 and 0211. Ms. Riley entered pleas of guilty in each of those, which are theft of property with previous convictions. The agreement on all of these was for a cap of 15 months in the state jail prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
Not from the defense.
Nothing from the state, Your Honor.
All right, Mr. Rojas, you may proceed.
Thank you, Judge. I know it's a big ask, Judge, and it's not something that the court, I think, probably is leaning toward, but we're asking the court to consider probation in all these cases. Ms. Riley is 27 years old. She's got 2 young kids at home. As you can see from the PSI, most of her previous offenses are theft or some type of deception cases. And certainly she's old enough to know better. She should know better. I think if you look closer at her background, it's a situation where she never really had a chance to get any kind of direction in her life. She was placed in the CPS custody when she was 3 months old. I think she lived with her aunt until she was 14. I think all that time, or most of that time, her mother was in prison. And when her mother got out of prison, Ms. Riley went back to live with her mom. From 14 to 17, at 17, she ran away from home. And I think her father's in prison now. I don't know how long he's been in prison, but he's in prison now. I think the easy thing to do is to go ahead and send her to the state jail. Not only for the court, the easy thing for Ms. Riley would be to send her to the state jail so that when she gets out, her slate is clean. She starts all over. I don't know that that's going to, I think if that happens, Judge, she's probably going to be back in the same place she's at, committing offenses, committing more thefts. What I'm asking the court to do is consider probation with possibly ISF, the cognitive track of ISF, so that she can get some direction, hopefully start learning how to make better decisions and get her life onto the right track. And I think, do you want to say something to the judge? Yes. At the appropriate time, she wants to say something.
Go ahead. No, I have had time to sit and think about my consequences. I wanted to I have talked to my aunt that I was staying with at first. She said that I could come back to stay with me and my 2 children. She's willing to help me try to get a GED and to get into the infirmary and the plant, like the refinements. So.
You need to look back. The NTRP case for me. How long she said? All right, Mr. Nichols.
Judge, I think the 15 months is appropriate in this case. Her misdemeanor history is incredibly extensive, lots of thefts, lots of probations that have been revoked. And if you follow the timeline, it's for committing thefts while on those probations, which is what she did here. Two new thefts, 6-7 months after being placed on probation for theft. So I think given her criminal history and continuing to commit crimes while on probation, I think 15 months state jail is appropriate.
Give me just a second. I want. Yeah. And if that's not easy to find,
What's the question, Ron? I know.
To this case?
no, I'm wanting to know, and it's not really going to make a big difference, but she said she's had time to sit and think. And what I wanted to know was how long she had to sit and think before she took the probation on the case she's on right now.
I can go back and look it up if you need it.
But so Miss Riley, you were on probation. You've had 1, 2, 3, 4, 5, 6, 7 probations. 7. You were given a probation for this felony, and 4 months later, you picked up 2 new theft cases. You've had every opportunity for whatever help it is that is out there. It's not like you've just taken time and not had opportunities with probation to help you. And so at this time in cause number 24 DC, excuse me, 24 DCCR 1778, I'm going to find that you entered your plea to true, freely, and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 26 DCCR 0210. Find that you pled guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, cause number 26 DCCR 0211. Find sufficient evidence to find you guilty of theft of property. Find you guilty of that offense, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of those cases that shows that these were agreements that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. There's a real easy way for you to stop being incarcerated, and that's to stop stealing. You can't expect to keep doing the same thing and not have more harsh consequences. And so you need to understand that when you get out of state jail, if you do this again, it's going to get worse every single time. So if you want to be there for your kids and break the cycle, then that's going to be up to you to break that cycle. All right. Go back with the bailiff. Charles Verdine.
Carlson,
Charles Sine Verdine. Charles Sine Renee Verdine.
You have Charles Verdine.
We've already met.
I have. This is okay. This is. Charles Sine.
Have all the Verdines.
Mm-hmm.
This is
Different.
Yeah. Well, good morning, ma'am. Are you Charles Sine Verdine?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
And Judge, the reason for this offer, if the court is inclined to follow it, just so you know, the motion was actually filed 10 days before she was set to expire out completely. So we're just trying to double back and address the addiction issue.
All right, Ms. Verdine, in cause number 22-40028, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 25th of 2023 for the 3rd-degree felony offense of obstruction or retaliation, and that was a 3-year deferred probation. Is that correct? The motion alleges that you violated your probation. Is that 1 through 5?
It is, Your Honor.
Count 1 alleges that you provided a urine sample June 26th, October 15th, and November 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
Yes, ma'am. True.
That's marijuana.
It is true.
Okay. Count 2 alleges that you failed to successfully complete the GED program as directed. Is that true or not true?
True.
Count 3 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you tested positive for alcohol June 26th and October 15th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to submit to alcohol or drug screening October 14th of 2025. And is that true or not true?
True.
And then count 5 alleges that you failed to successfully complete the moral recognition therapy program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue your probation and extend it for 2 years. Order that you enter and successfully complete the JCDI program, which would also include a drug patch. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted any evidence that Ms. Verdine is not competent.
Oh, yeah.
So I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I do want to get an updated report. So we need to figure out between now and then what I can do between now and then. I just want to make sure that probation also agrees that that's all of the treatment and everything that's necessary. I'm willing to set a bond, and she's on probation. She can go ahead and start those programs. But I want to make sure, I think that we're covering everything, if that makes sense.
Judge, she's been incarcerated for a while. Would the court consider PR bond?
Yeah. So, okay. So what I'm going to do, Ms. Verdine, is I'm going to reset your case for sentencing. I'm not going to sentence you and extend it today. We're going to do that later. But I am going to reduce or set a bond for you in the amount of $1,000, but make that a personal bond, which means you don't have to pay any money. You're just going to get out of jail.
Yes, ma'am.
You're still on this probation. You're required to do everything, including starting that JCDI program. You have to have a drug patch on within 24 hours of your release from custody.
Yes, ma'am.
If you don't do that, I don't have to go along with this agreement when you come back. If you test positive between now and then, you're going to be right back in jail. Do you understand?
Yes, ma'am.
You can talk to your probation officer about where to get that drug patch. They'll help you with that. And then we'll see you back at sentencing. Okay.
Yes, ma'am.
All right. You can go back with the bailiff.
I have a question.
Hang on just a second.
Is the drug patch right now just gonna be a condition of a bond? Or,
It's going to be both.
okay,
It needs to be a condition of probation and bond. Yes, ma'am.
I forgot what I was saying.
Sorry.
So I forgot.
Okay. If you think of it, Mr. Rojas will be around and you can tell one of the bailiffs. All right. You can go back to the bailiff.
Judge, may I report?
Yes, ma'am. In just 1 second. Let me write this down before I forget. Yes, ma'am.
That's such he's on vacation this week.
Okay.
So if we could reset 1 week, he said he'll be back Friday, so.
Let's reset it 2
And
weeks.
he's hired misdemeanors.
Let's reset it 2 weeks.
But really, so. Ashley still in this, but Audman has to leave him on his misdemeanor.
On Daniel Eli, we're going to do 2 weeks because if we just do it a week, he's not going to have time. And if he goes and takes care of it, you can just dismiss it without him coming back here. Okay.
Yes.
All right. That's Daniel Eli.
Yes, ma'am.
And then Anthony James.
Yes, Your Honor, if we've received an offer, an adjusted offer, if we can have like just 2 weeks or something to get with his family, it's a TDC.
Okay. We're going to reset, we'll reset James a couple of weeks. Mr. Lewis, you have 10 fam?
Yes, ma'am.
Are they all state jails?
Yes, sure. This one.
Enhanced at all?
No, I think he has, anything done hands on. But they're stackable.
Those are all different dates.
Yeah, here it is.
And y'all talked about that?
Yes.
Okay. Good morning. Are you Tan? You're Tan Van Pham?
Yes, ma'am.
And Mr. Pham, you are charged in cause number 25 DCCR 0909 with the state jail felony offense of theft of property from May 3rd of 2025. If you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in state jail prison. Do you understand?
Yes. Depend on my lawyer. If she say yes, I have to say yes, ma'am.
No, I want to make sure you understand. And do you understand? Do you need an interpreter? Would that be better?
Yeah, that's better because I don't understand it very well.
Well, we've been able to communicate.
You have.
You know,
the whole time.
Yes, ma'am.
So, Mr. Pham, if you go, I just want to make sure in all of your cases, every single case, you've got 25 DCCR 0909, 25 DCCR 1039, 26 DCCR 0353, 54, 55, and then we've got 25 DCCR 0782 and 0785. All of those cases charge you with theft of property with previous convictions, which means if you're found guilty, the range of punishment, you could go to prison for a minimum of 6 months up to 2 years in each of those cases. Do you understand that?
I know, but I don't do like that, you know.
I just want to make sure you understand that if a jury finds you guilty, what the range of punishment is. What could happen?
I don't know what it means because my English not too well, you know. But I don't do like
We're going to reset it 1 week. Let's get figure out who we can get as an interpreter, please. You speak Vietnamese?
Yeah, I speak with them.
Okay, we'll see you next week. We'll figure it out.
Okay, thank you, ma'am.
Yes.
Thank you so much.
I don't know. Yeah. And then Mr. Rojas, Justice Lars.
Yes, ma'am. Wants to talk to him.
He wants to do what?
Talk to the court again. He wouldn't.
Let's get Mr. Larzo out real quick, please. Thank you.
Maybe if I connect you off, it'd be very, that's what it is.
You see, like the price is right. Remember that game the little guy goes. Little mountain man's going.
There's so many words are allowed. Yeah. All right, Mr. Larzo, what's going on?
I'm going ahead. I want to request a new lawyer. He's not representative.
Here's the thing, you don't get to do that. So here's where we are. Mr. Rojas is a great lawyer. He's not just because nope, not while I'm talking. I already gave you an opportunity earlier and I'm going to give you an opportunity in a minute, but I want you to listen carefully to what I have to say first. Okay. Mr. Rojas is telling you what the district attorney's office is offering. You don't have to like it. It doesn't mean he's a bad attorney. And another attorney is not going to come get a different offer.
Okay.
So, Ms. Malfino, is there any reason that you would know of that offer that you have made would change?
No, it will only go up.
So you're where you are. So either you accept that offer or we set your case for trial. Once your case is set for, hang on.
I want a new lawyer. I don't.
Hold on. I understand, but listen.
You want to let me speak, man? Please, can I speak?
I'm going to let you speak, but I'm going to give you what your options are, okay?
All I want is what I'm saying. You trying to say trial, this and that. I haven't even seen my discovery evidence. You saying he's a good lawyer, but he haven't even shown me no evidence. So on my case, how can you speak and say he already told me the other day that he working for the DA? He already said. I said you haven't. He have not one asked me what happened. He haven't even got my side of the story. Have you got my side of the story? Have I told you what happened in this case? Can you tell this person what I told you?
Mr. Larzo, you're not in charge and you're
I'm
not
not saying
asking
I'm not in
questions.
charge, but what I'm saying is, how can he say he can represent me and he's ain't done nothing but come to me and say the DA said this, the police report said this. He has not.
That's the evidence. That's what he's telling you the evidence is what's in.
What the police report said, but he hasn't asked me my side. And
here's the thing, your side is important if you're going to, if you didn't do it, what his job is to tell you, this is the evidence they have against you. You can take this deal, or if you say you didn't do it, you can go to trial. So if you're saying you didn't do it, then let's get a jury to determine if you did it or not.
I haven't seen no police report. I haven't seen no body cam footage. I haven't seen no evidence to where I can tell you if I'm ready to go to trial.
Is there media in this
Judge,
case?
if, as Mr. Rojas does in every case, he has requested and reviewed the discovery well in advance.
Do you want, let's do this. Do you have some media?
Judge, I have requested the media. What I told Mr. Larzo yesterday when he told me he wanted to watch the video, I told him we could reset the date to look at the video. He just said he didn't want to do that. He just wanted to come in and ask for a new lawyer.
I want a new lawyer because you now represent me effectively. You come to me and tell me the DA said this.
Mr. Larzo, he just said that yesterday he would bring the videos. Don't talk over me. He would bring the video for you to watch. I'm going to reset your case for 2 weeks. He's going to bring the information. You can watch it and you can make your decision. The offer is what the offer is. The DA's already said that. I don't care if you take it or if you don't take it. Take it, fine. Don't take it. We'll get your case set for trial. You need to be respectful. Mr. Rojas is going to get out there, show you everything. You don't get to keep copies of things by law. He doesn't get to hand you a police report and you keep it. That's part of the law. So he can go over that with you, read what it says to you, show you the video, and then you can make your decision. Go back with the bailiff.
When I ask a question,
Nope, I'm done today. Go back with the bailiff.
I understand how you can give somebody 4 years for an aggravated charge and try to offer me 5 years for non-aggravated.
So he's not happy with that.
DeMarcus Elam, wait, hold on, Mr. Burbank, what are you doing on Mouton?
Mr. Mouton,
I know, what's the announcement?
I'm still on discovery. I just got appointed and I've talked to her. I think also based on that, I may need to have her evaluated somewhere between here and there. My request based on the circumstances.
Here you are. What?
Evaluate.
Somewhere between here and there?
Yeah, well, my motion is here between here and there. The evaluation, it's coming, but
Okay.
today or tomorrow.
Okay, we'll reset this Mouton.
And I've talked to her. She knows what's going on and
All right, yeah, if you'll make sure you get that in, we will get her evaluated as quickly as possible.
maybe I can convince Mr. Smith to.
DeMarcus Elam.
Just.
Yeah, DeMarcus Elam. Mr. Smith, you've got DeMarcus Elam, writ hearing. Good morning. Are you DeMarcus Elam?
Yes, ma'am.
And this is cause number 26, DCCR 1221. Mr. Elam is charged with the first-degree felony offense of murder. And Mr. Reynolds was appointed as attorney. Ms. Holmes is stepping in to help out on that as well, and they have filed a writ requesting for a reduction in Mr. Elam's bond, which is currently set. Oh. Yes. Oh.
Yes, I believe Mr.
Did I know that ahead of time?
Okay.
I'm sorry if I didn't make that clear. No, I guess not, because I'm not gonna, so here's the thing, when you have an attorney, you don't get to have what we call dual representation. So if you, and I don't mind.
I think it's, if I could clarify, it was filed pre-indictment. I'm not sure when Mr. Reynolds was placed on it, but Mr. Elam had filed the writ prior to being indicted, and then after the writ was filed, his case was indicted.
So it's been indicted at this point.
Yes, ma'am.
Okay. So here's what I'm going to do. What's the bond currently set at?
$2 million.
Okay. So what I'd like to do, I'm not going to, because the case has been indicted. At this point, a writ is probably not the appropriate tool. I would think it would just be a motion for a bond reduction. Ms. Holmes can talk with Mr. Reynolds. They can get that filed. They're going to file things on your behalf. Okay. And so I understand that you were waiting on an indictment, but that's been taken care of now. But you don't get to file something if you have an attorney. I'm going to take what they filed. So let's get a bond reduction. Ms. Holmes will get that filed for you. I'll reset the case 1 week, but I think we need to have the appropriate tool moving forward legally. Let's do 2 weeks, and we'll have a bond hearing. If the state has any evidence, that'll give them some time to bring anybody, if you wish, on a bond reduction hearing. Okay, so we'll see you back in 2 weeks.
Okay.
Yeah. Yes. Yes. That.
Okay, Aaron Parr and David Lorenzen in Otsego.
Yeah, I'm in Kalkaska today, so you're probably looking for Judge Hunter. He's in Otsego.
Thanks, Judge. Okay, I'm definitely in the wrong room. I apologize. Thank you.
No problem. Okay, I guess we're gonna have to pass. I don't see anybody from the AG's office calling in. Mr. Travis, have you had any discussions with the AG's office on this one?
We did a stipulation to get Mr. Orlow out. I did send Ms. Brenner an email that I have not gotten a response from, but it didn't really require a response. I thought I did.
Well, let's just,
yeah, on July 1st, I'd sent her an email. And I haven't heard back from her, but it was just basically saying we were going to be asking for an adjournment and giving her some information about Mr. Orlow working and giving her a chance to know that ahead of time. And she hasn't said, and all I said is if you have any, disagreements or issues with this, please let me know. So,
okay. All right. So you were going to request an adjournment of today's hearing?
Yes, Your Honor. Mr. Orlow's out. He's working. We don't even have a formal offer, but unless policies have drastically changed, I kind of think I know where this is heading. And he'd just like to basically pay as much support as he can before hopefully we start a delay type offer that has not been formally offered.
Okay. How much of an adjournment for today?
60 days, or even actually he's got a hearing in September to get his support lowered. So I know it's quite a bit, but even 90 days, we may come back in a substantially different situation for Mr. Orlow if the court wanted to. At 60, we will probably come back just having paid some money, more money. He's got a withholding in place currently and then paying.
All right. I'm going to set it for 60 days. At this point, if we can get a plea at that time, then that's how we'll proceed. If not, then we'll go forward from there. But without other counsel here, I think 90 days might be a little bit.
Yeah, I understand.
Long. So we'll set it for a status conference plea hearing in 60 days. Mr. Orlow, between now and then, it's important that you stay in touch with your attorney, Mr. Travis, and that you're ready to proceed at that next hearing. Did you have any questions about how we're going to proceed with your case?
I did not. My lawyer's been very clear about everything and we're in agreement. I just want to get this stuff done and taken care of quickly with me.
Okay. All right. Thank you.
Thank you.
Thank you, Adam.
People versus. Mr. Travis, do you have anybody right now that we can take on your dot?
I don't believe so, Your Honor. I think that. Next matter is a sentencing at 10, and Mr. Schmarsh is not here yet.
All right, next hearing's at 9:15. We'll just take a short recess.
No, I will be making.
On behalf of the people, Your Honor.
Thomas Seeger, bearing with me on behalf of Ms. Fleming. Mr. Seeger, can you tell me the status of this file this morning?
Your Honor, I'm not entirely sure what the position of the Department of Corrections is. This was really related to court costs and fines wherein payments were allegedly not made. In any event, Your Honor, I did at one point in time speak with the Department of Corrections asking whether or not payments were made, and it sounded as though they weren't specifically made. However, when I did discuss it with her, one payment, I think of $50 had been made. However, in speaking with Ms. Bunning today, she indicated that she had made a payment today of $100. She had lost her job and was unemployed for a period of time. She subsequently just received new employment and is hopeful to be able to exhaust the matter within a period of 90 days. But I guess it would defer to the department in terms of how they wish to proceed.
Ms. Wagner?
Yes, Your Honor. She's been on probation for over a year and she's made very minimal payments. She's had employment on and off since that time. This is the only thing keeping her on probation. She's due to discharge on August 6th. She's already been extended once. I'm not opposed to extending it an additional 90 days beyond that to allow her to pay. I think if she's not paid in full by that date, we probably need to move on with a sanction or something. This is the only thing keeping her on probation.
Okay. Ms. Bunning, what's your current situation?
I just got a job making $27 an hour daily pay. So every day I work, I will be making a payment to get it paid off quick.
Okay. All right.
It's like a 1099 self-employment type of thing.
Okay.
So every day that it's at the end of my day I work, I get paid Cash App or Venmo, and I'll probably have to pay it online because I won't make it in time to pay cash, but
Is this a pretty consistent?
yeah, yep.
What kind of work are you?
It's housekeeping.
Oh, okay.
Yep.
All right. Is it like, are they one-time jobs or do you have like work every single day?
Almost every day.
Okay.
Yeah. Especially on the weekends, probably like every Saturday at least, but I know like I work tomorrow, so I make a payment tomorrow, and then I work Friday and probably Saturday. I'm not sure after Friday what my schedule is, but.
Okay. And is this like private residences? Is it like resort?
It's a resort. I don't know if you heard of Spider Lake in Traverse City.
No.
Well, anyway, it's like a resort, and then we have houses all over the place that we all go to, so it's pretty consistent, except for in the wintertime, obviously, but yeah, it's pretty decent. So
Okay. All right, then, Ms. Wagner, I'd like to go forward as you've suggested to continue monitoring Ms. Bunning's payments and extend for 90 days and then we'll see where we're at that point.
Okay, thank you. Can we put her back on the docket then in 90 days, just to keep it going?
Yes.
Unless she's
Yep.
paid in full. If she's paid in full by that date, I'll submit the discharge to the court.
Right. Okay. Exactly.
Thank you.
So Ms. Bunning, just make sure you stay in touch with Ms. Wagner.
Okay.
Did you have any questions at all?
No, I was just gonna see if I had to let her know when I had them paid off and stuff and go from there, but I guess if I sound to it, that's what I need to do, so.
All right. Thank you.
All right, thank you.
Okay. Do we have Mr. Yoder present?
Yeah, Mr. Yoder, it's a suppressed file, but Mr. Yoder was in court yesterday for an unrelated matter. I don't know if he was aware that he had court today. I don't want to say it's just an arraignment, but it was an arraignment yesterday, which he appeared at. He was incarcerated, so I don't know if he's still in the Wexford County Jail. That may be one possibility because I'm not sure if he made bond. And second, if he's not, I'm not sure that he was aware that he had an arraignment today for this matter.
Is this like a show cause arraignment?
I'm not really entirely sure. It's just an alleged violation of the conditions of probation. I guess you would have to ask Ms. Wagner's.
Ms. Wagner, do you have any additional information on this?
I do, Your Honor. I have not seen him. The last time he reported to my office was on April 16th. He was set to report on May 21st and failed to report. He has not reached out to me. I've had no contact. I just found out this morning that he was arrested for drunk driving on July 4th. He is bonded out as of that date. I'm waiting to hear what his bond conditions are. I would assume he's got to be on daily PBTs. I have not received a return to sender notice from the letter that was sent to his house and instructing him to report today. So I would just ask that a bench warrant be issued. He's pretty much over the 60-day mark at this point for not reporting.
Okay. All right, then if you can prepare a bench warrant for his failure to appear. I'm just noticing, the file doesn't reflect any mail being returned. So we'll proceed once we have Mr. Yoder in custody.
Thank you. I will get that to you.
Thank you. Do we have Mr. Rauch here?
Yes, ma'am.
Sir, if you come forward up to the podium, please. This is file number 265186. Executive counsel putting our appearances on this file.
Brian Ziegler on behalf of the people, Your Honor.
Thomas Cedar appearing with on behalf of Mr. Welch.
Mr. Seeger, can you tell me the status of this file today?
Your Honor, we are still trying to attempt to reach a resolution. The case is somewhat complicated in as much as there are two other files that are allegedly outstanding that have not been authorized at this time. And so I know that that really doesn't have anything to do with the court's docket, but it is a consideration in terms of how we may resolve things. I think that we were waiting for labs to determine what they were going to do, if anything, with those files. Or if those files do catch up, I assume that some global resolution will be reached in some fashion or form. And if not, I guess all matters will proceed to trial.
Great. I guess what I'd like to do is get this on the trial docket, and then I'm happy to build in enough time, Mr. Seeger, for you to get what you need. What do you think would be a reasonable?
Your Honor, I think if you gave us 90 days, that would probably be enough, but I would defer to Mr. Ziegler. He would probably have a better understanding of where certain matters might be and what other things may occur.
I do have one of those labs back, Your Honor. I'm just waiting on another one. The labs has been fairly inconsistent over the last few months. Sometimes I get them back fairly quickly. Sometimes it just takes months, and I don't know what the holdup is. But I think if you gave us 90 days, we'll either have what we need or we won't, and we'll reach a resolution or we'll have a trial.
Okay, so if I were to set the trial at 120 days out with a final conference at that 90-day mark, and that's the plea cutoff, does that sound?
I think that would be fine.
Yes, Your Honor.
Okay, so and Mr. Ziegler, how many days of trial do you think we would need?
Your Honor, given that the nature of the case, I would err on the side of 2 days.
I think that would probably be the worst case scenario, but I would suspect based on the certain things that it would probably take a day, but 2 days would probably be best.
Okay. So we'll set it for a jury trial at about 120 days out. For a 2-day jury trial, the court will set it for a final status conference 30 days prior to the trial date. That will be the plea cutoff and the motion cutoff. So to the extent there are any motions to be filed, that would be, they would need to be filed and heard no later than that final status conference. So, sir, that just means over the next 90 days, you need to make sure that you stay in touch with Mr. Seeger, that you communicate with him. Your next hearing in court, unless somebody files a motion, would be in about 90 days. That'll be the plea cutoff. So that means that
after that, there's no plea deal.
Right. You would need to be ready with the final decision as to any offers on that date. And then you'll get notice of that date as well as your trial dates, which will be, again, in about 4 months. Do you have any questions about how we're going to proceed with your case?
No, I do not.
Okay, Mr. Seeger, any other dates that we can address?
No, Your Honor. But generally it.
No, Your Honor.
All right, thank you. That's all for today. So
and Your Honor, Mr. Kite's not set until 9:45. However, said he's about a block away. So
okay, you can just let us know when he's ready. Proceed on that case. Take a short recess until then. Okay, so the 265209 file is going to be dismissed in its entirety?
Correct.
Okay. All right. And Mr. Kite, have you had an opportunity to go through the pre-sentence report of Mr. Seeger? Mr. Seeger, are there any additions, deletions, or corrections?
they're not, Your Honor.
Are there any challenges to the scoring?
They're not, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, I support the recommendations in the report. Ordinarily, under these kinds of circumstances, I would not be doing so. Mr. Kite's record certainly does not recommend him to a fines and costs resolution on paper. There's multiple files, there's multiple counts. But in the last several months, Mr. Kite has put in the work. He's begun to address his substance abuse issues head on. He's been involved in an abuse and neglect case for about a year now. And his progress in that case has been a complete 180. At the start of that case, he was very uncooperative, not doing what was asked of him, testing positive for controlled substances. Over the last several months, he's now testing clean. The reports that I received from the Department of Health and Human Services regarding Mr. Kite are excellent. Mr. Kite's conduct from a year ago when these offenses occurred do not warrant a fines and costs resolution, especially given that he has a prior drug conviction. But his conduct over the last several months demonstrates he's a good candidate for rehabilitation and that he's already taken measurable steps towards bettering himself. I think jail would interfere with those efforts that he's currently making. And I think probation in this case would be redundant, given that he's already being monitored in the abuse and neglect case. So for those reasons, Your Honor, I support the recommendation of fines and costs.
Thank you. Mr. Seeger?
Your Honor, I pretty much can't say anything better than Mr. Ziegler had just stated. When this case originally had begun, at least related to the neglect and abuse case, I really did have some doubts about whether or not Mr. Kite would be able to resurrect his parental rights, but he has worked very diligently in maintaining his sobriety. He has worked very diligently in accordance with the case service plan. I know that the case service plan and the criminal court do not exactly coincide with each other, but I do agree with Mr. Ziegler that based on his continued progress, that some kind of incarceration would only impede his progress. And so I would ask the court to adopt the recommendation. I think that this has been a very much a learning lesson for Mr. Kite. I did express to him that to the extent that the court follows this recommendation, that there can't be any more hiccups either through the neglect and abuse proceeding or in the alternative, some new criminal charge, as the court is gracious in many instances, but as with anything, give demonstrations and your record will catch up with you at some point in time. To that end, Your Honor, I think that he has turned a page in his life. He's hopeful to be reunified with his children. That is likely to be a feature of the case service plan in the upcoming months. He's expressed a want to change. He's expressed a want to continue on with his sobriety. And again, it's strange because when he originally had started, I really did not have a lot of hope. And ordinarily, those are the types of cases that usually end in termination of your parental rights. But he has really changed his life. And I think Mr. Ziegler said it best that, you know, it really was a very surprising moment for not only Mr. Ziegler and I, but also the family court judge and the guardian ad litem. So to that end, Your Honor, I would just ask the court to consider following the recommendation, giving him court costs and fines, and he will continue to be monitored by the Department of Health and Human Services. And should he have problems, certainly that's going to create problems for him in the other realm. But hopefully this is a situation where he's no longer in criminal court.
All right, thank you. Mr. Kite, anything you want to?
Yes, Your Honor. So sitting in jail for my other drug charge, I had a lot of time to think about what was going on and what was happening in my life. And I came to some realizations, and number one was it was not the victimless crime that I had always treated it as. Calcasas was wasting resources dealing with my nonsense. I was putting the officers in harm's way every time they had to search me, and I had harmful narcotics or needles on me. I was putting them in danger. And I was neck deep in addiction that I'd had for a long time. So I had time to realize the problem and figure out what I was going to do about it. My probation recommended outpatient counseling once a week, but I had to be honest and really ask myself, did I think an hour a week of counseling, do you think that's going to handle what you've been doing for the last better part of a decade? And the answer was no. So I took myself to rehab and got the treatment that I needed. I've been clean for 9 months. A little over 9 months now. I am tested weekly. I have not tested positive a single time. I know I have to answer for what I did, but I'm doing things differently now. And this case is actually a good example of how I'm doing things differently. I was in rehab when I found out about this warrant, and the old me would have just left rehab. I'm going to jail anyway. Just go off the rails until they catch you again. Instead, I decided to stick out rehab, get everything I could out of it. And then I walked into the jail and turned myself in to handle the situation. So I'd just like the court to know that I do take my sobriety seriously. I can't imagine how many people get up here and make a bunch of promises. I'm going to do this. I'm going to do that. I'm actually doing. That's all, Your Honor.
All right, thank you. Mr. Kite, I did read through the report, and so I'm familiar with the information contained in that report, including about both files. The report, even though you're being sentenced on one, contains information about the other case as well. Also information about your background and your circumstances generally. And I take all of that into consideration along with what the lawyers have had to say here today and yourself, of course. And I mean, I agree with all three of you. When I first read the report, and I usually start with the description of the offense and look at your prior history and so forth. I was surprised until I read the recommendation, and then I understood kind of why the recommendation was what it was. Because there are a lot of negatives in your past history and with regard to these offenses, and you've been on probation a number of times, you've been to jail a number of times, and you know, now is a really good time for you to get your arms around this, because myself or any other judge is going to have a hard time ordering jail or probation again. You're going to be looking at prison time. which is a completely different experience than what you've had so far. And I hope that it doesn't come to that. I think you are taking steps to prevent that. And I think that's a good thing. Based on everything I read in the report and what the lawyer had to say here today, it sounds like you're getting things on the right track. And just from what you had to say, it sounds like you're looking at this from the right perspective, which is not what is the court making me do, but what do I need to do to get myself on the right track? And that's really the right question, because the court can order everything, but until you actually want to do it, it's not going to make much of a difference. So I'm really glad to hear you say that. To me, that gives indications that you're going to be successful as you go forward. And I hope that is the way that it turns out. In terms of this case, I do think the recommendation is appropriate, particularly because there is oversight and testing outside of this file. And I agree that probation here would be duplicative. And you did serve a few days up front on this. The guidelines are 0 to 11. This is a nonviolent offense. So I think given your progress and circumstances, that the recommendation is well crafted. So the court is going to follow that. Court is going to send you to 5 days in the Kalkaska County Jail with credit for 5 days served. A crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and we're going to provide you, Mr. Seeger, if you can have Mr. Tepe now receive.
Your Honor, we were denied receipt of the appellate rights and the security have you seen return it. Thank you.
And good luck to you going forward. Thank you.
Yeah.
And I'm leaving court now. So if I have another matter, I didn't do it on purpose, but
okay.
I think that is over.
Don't see any more.
Okay.
I think I have one matter, Mr. Travis, before your case, but you can stay right there. Actually, while we're waiting, Mr. Travis, we can take that file, Black Collection activity. So, sir, can you tell me how to pronounce your name again?
Last name is Smarsh.
Smarsh, okay. And we're on the record in People versus Smarsh. This is file number 265190. Mr. Smarsh is present here in the courtroom today. Executive counsel, put your witnesses on.
Ryan Ziegler on behalf of People, Your Honor.
Kyle Travis on behalf of Mr. Smarsh.
This is the date and time set for sentencing in this matter. Mr. Smarsh, have you had an opportunity to go through the pre-sentence report and talk to Mr. Travis about that?
Yes, sir, I did.
Okay. Mr. Travis, are there any additions, deletions, or corrections?
Not that I'm aware of.
Any challenges to the scoring?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, I support the recommendation in the report. I think a slightly longer term of probation makes sense given the guidelines of 0 to 9. I don't believe that any upfront jail is warranted in this case, primarily given his physical health limitations and given the fact that his family is indicating in the report that he's in a better place now than he was at the time. I think the recommendation is fair and reasonable, and I'd ask the court to adopt it.
Thank you, Mr. Travis.
Yeah, similarly, we would ask the court to adopt the recommendation. Mr. Schmarsh can give you some more about what he's got going on, but I think he has both in his physical health and where he's at mentally in a better spot than he was. Obviously, he does have some older criminal history, but he had gone through basically a pretty bad period with his physical health and his relationships, and I think it was just in a pretty negative space. He's back, I would say, on the upswing as he comes to court. He was discussing with me different steps he's taking relative to substance abuse and relative to his physical health that are all positive. Thank you, Your Honor.
Thank you, Mr. Schmarsh. Anything you wanted to say today?
Well, basically all I want to say is I'm sorry for wasting the court's time. Yes, I was going through a bad situation with my ex now. Basically, she walked out on me, left me for dead. I laid on a couch for 2 months. I barely got up to even use the restroom, which resulted in amputations. Now I'm dealing, I made the bad decision of going where I went, and I know better. I'm 51 years old. There's no excuse for what I did. I basically gave up on life. And it come down to the point to where my mom had to come over and literally force me out of the house and to go to the hospital. When I got to the hospital, my sugar was over 2,200. I don't know if you're aware, but on average, you're supposed to be between 70 and 120. My body was full of sepsis and whatnot. Like I said, I literally just gave up. And now that this brought light to my head that this is not where I want to be. I got kids, I got grandbabies, and I need to be here for them. I need to be a positive role model because not as an excuse, but they're down there in Flint, and I don't want them down there no more. I have custody. Well, I'm getting back custody of my youngest daughter. She's 15 years old, and so far, when I brought her over here to be with me before all this bad stuff happened with the ex, she went from 6 schools in 2 years and all E's, no friends. And she brought her grades up and whatnot. And that's what I want to continue with her, because nowadays children don't have, I'm sorry, but they don't have the work ethic of us older gentlemen and ladies that, we can go out and do physical labor jobs and make a decent living. So I've been pounding in their head, school. But if I keep this route going, I ain't going to be nothing to them. And that's not what I want. I've been seeking help already so far. I've been to AA meetings, searching for an NA meeting over there in Baldwin where I live. I've registered to see the mental health lady there at my doctor's office, and I've been in contact with my doctor on a regular basis to bring all this back to a normal situation the best that I can. I picked up work since the last time I was in here. I'm doing a couple demo jobs, yard cleanup stuff, and then I got a flooring job coming up beginning of next month. So as long as I keep pounding the pavement and doing what I'm doing, I believe that I can be an asset to this world. And basically, all I'm here to say is I throw myself on the mercy of y'all, and hope you oblige by the probationary, and I won't disappoint anybody in this aspect. Because like I said, if I keep going this way, I'm either going to end up in prison or dead. And I don't want either. So.
Okay. All right. Well, I did read through the report. I'm familiar with why you're before the court today. I'm familiar with your background and circumstances based on that information. And yeah, I mean, I think you're right. You are going to end up in prison or dead. And somebody with your health problems shouldn't be using substances at all. And I'm, honestly, I think if you continue to use that, it's going to be really difficult for you to go forward. Yeah. And I do think probation is appropriate. I'm going to order that primarily due to the circumstances of the charge here. But I want you to understand that your health issues aren't going to be a reason for me to not put you in jail if you don't comply with probation. Because if you continue to use and violate probation, particularly if you're tested positive, that's telling me is that you don't really care about your own health. And if you don't care about it, why should I care about it? So I just want you to be clear that I recognize that you got some health limitations, but if you continue to use and violate your probation, that will not be a reason why I would not sentence you to jail if you're guilty of violating your probation. I hope it doesn't go that way. As I told the previous gentleman, I hope that you do comply and that you take your health more seriously as you go forward for all the reasons that you've stated. The court is going to place you on probation for a period of 24 months. The court is going to adopt as the conditions of probation all the terms and conditions listed in the report. And that includes that you not use or possess any controlled substances unless they're prescribed to you, that you comply with any alcohol or drug testing, that you not use or possess any alcoholic beverages or other intoxicants, along with all the other conditions. The court is going to order 6 months in jail. I'm going to hold that time in abeyance. So if you comply with your probation, you would not have to serve any of that time. If you fail to comply, then I can order you to serve any or all of that time immediately without a hearing, nothing, just right to jail. You do have credit for 1 day served. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60 and a $68 state cost, along with a supervision fee of $30 per month while you're on probation. You do have the ability to seek an appeal of this sentence. And Mr. Travis, if you can, Mr. Smarsh, now with receipt of his appellate rights. Yeah, Ms. Wagner, do you need Mr. Smarsh to check in at the office here today?
I do. Thank you.
Okay, so Mr. Smarsh, before you leave the court, check in probation. Okay. And good luck to you going forward, sir.
Thank you very much. Once again, sorry to waste y'all's time.
Yep. All right, sir, at Wexford County, can you tell me your name, please? I'll need you to unmute.
Ken Wilkie.
Okay. All right, we're on the record in Wilkie, People versus Wilkie, file number 265180, 265221, and 26522. The latter two files are newly bound over to this court. We're having our first hearing in each of those files today. The other file, we're proceeding on. Mr. Wilkie, I believe, failed to appear for a hearing, and so the court issued a bench warrant for his arrest, and he was arrested on that on June 12th.
May I speak, Your Honor?
Yes.
I had adjourned. I adjourned the matter before you, and you had said it would be within 30 days. I never received notice of that. I have retained an attorney, Damian Nunzio, but I never received notice that I had a hearing before you. That's why I failed to appear. So my attorney that I retained is Damian Nunzio. I don't know if he's filed an appearance with you or not. I was scheduled to have a hearing yesterday at 9:45, and wasn't brought before you.
Well, I don't have any record of a lawyer filing an appearance on your behalf. So when was the last time you talked to Mr. Nunzio?
My mother talked to him. I haven't talked to him personally because I'm incarcerated. My mother talked to him last week.
Okay.
I assumed, because I was scheduled for a hearing yesterday at 9:45 and wasn't brought before the court, that something had transpired between my attorney and the court.
No, we haven't had any contact from an attorney on your behalf.
Did I have court scheduled for yesterday?
No, not in my court. I don't know if you had a different court.
Well, my paper says that this court in front of you, Honorable Mertz.
I don't know if you're not looking at the.
On the 7th. Is today the 7th?
Yeah, today's the 7th.
Oh, okay. So it is today. I'm sorry. I had my days mixed up.
That's okay. Yeah, so we don't have a lawyer who's made an appearance on your behalf. We sent the notice of hearing in May and June to your address that we have on file on Underhill Road there.
Yeah, I never received anything about a court day prior to the hearing.
Yeah, it never came back to us. So how do you want to proceed today? I mean, do you want to proceed without a lawyer? Do you want to have your get a?
No, I need to contact my lawyer.
Okay.
He's already received a retainer, so.
Okay.
I thought, yeah, so that's how I'd like to proceed, is an adjournment, and I'll get a hold of them.
All right, Mr. Ziegler.
Your Honor, I'm sure the court's aware of all of this, but just for the record, back in May, Mr. Wilkie made the exact same claim that he had hired an attorney by the name of Damian Nunzio. I did look him up back in May. He is a real attorney from downstate. I have not received an appearance from him in the last 2 months. It sounds like the court has not either. If Mr. Wilkie's indicating that he has hired Mr. Nunzio and that he's going to file an appearance, I don't have an objection to another adjournment, but I'm not going to play the game where we continue to do this indefinitely.
All right, so Mr. Wilkie, my notes are the same as what Mr. Ziegler just indicated, that back in May you did say that you had an attorney, so we set it for June, and then you didn't appear in June. So I'm gonna grant your request for the adjournment today. If you don't have Mr. Nunzio file an appearance between now and your next hearing date, then we're going to have to move forward with your case one way or the other. Do you understand that you would have the right to have the court appoint an attorney for you if you couldn't hire one yourself?
Yeah, I would reject that as being a problem with separation of powers. He would be paid by the same court that's prosecuting me. So I would object to that, but I do have an attorney that's already been paid, so he's already received the money. So I just need to get a hold of him, I guess. So
okay. Well, number one, I want to make sure a couple things are clear to you. Number one, the court isn't prosecuting you. The people of the state of Michigan are prosecuting you. The court is the forum where that prosecution is taking place. And the court is not the one paying for the court-appointed attorney. So they're paid through the Michigan Indigent Defense Council. So I don't know if that changes your mind, but I want to make sure that you understand the actual facts.
But as I stated, Damian Nunzio has received a retainer fee from me, so I just need to get hold of him. And then let's see what's going on. I thought that things were taken care of. I have to communicate through my mother, and she's old and she doesn't really understand a lot of things anymore. So.
Okay. All right. As long as you're clear that this is the last adjournment. Hey guys, can you have this conversation outside the courtroom?
But I apologize for your inconvenience, Your Honor. Like I say, I'm incarcerated, so, and I did not receive notice of the last court hearing. That's why the bond was, that's why I didn't appear and my bond was revoked. So,
It's not about inconvenience, Mr. Wilkie. The people have the right to a speedy trial as do you. And so the court is required to abide by those rights. So I'm not going to just delay this indefinitely. So we'll proceed further at the next hearing as long as you understand that if Mr. Nunzio or anybody else doesn't make an appearance on your behalf, then we'll decide how we're going to go forward in terms of your representation, and we'll schedule it accordingly. We will give you notice of the date and time of that next hearing. And that's all for today. Thank you.
Thank you, Judge.
Okay. Do you have Mr. Bucco?
Yes, sir. He is in holding.
Thank you. Can you let Mr. Travis know we're ready on Mr. Bucco's case? We're bringing Mr. Bucco up.
Thank you.
All right, we're on the record in People versus Anthony Bucco. This is file number 265197. The record should reflect Mr. Bucco's present here in the courtroom today. If I could have counsel put your appearance on the record.
Ryan Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Bucco.
Thank you, Mr. Bucco. This is the date and time set for a sentencing hearing in this matter. Have you had an opportunity to go through the pre-sentence report and talk to Mr. Travis?
Yes, sir.
Thank you. Mr. Travis, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to the scoring? I'm sorry, there is no scoring on this. Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, I support the recommendation. It's clear from Mr. Bucco's history and what he's done in the instant defense that he's not a good candidate for probation. This is his 26th conviction. It's for obstructing parole's attempts to monitor him while he was released from MDOC. I read through the report. His comments in the defendant's description of the offense only solidify that probation is a poor choice. Frankly, had I known that that was going to be his attitude at the time we were discussing resolutions for this case, I wouldn't have made him a misdemeanor offer at all. But given that this is where we are and it was a plea to a misdemeanor, I think the county year is an appropriate sentence. If MDOC wishes to violate his parole and return him to prison, they're free to do that. But for the conduct at issue in this case, Your Honor, I think a year in jail is certainly warranted, and that's what I'd ask the court to impose.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, Mr. Bucco's been pretty understanding of the fact that he did this, pretty reasonable, actually very reasonable about how we resolved the case. The statements I think are just one, maybe somewhat taken out of context, someone being overly honest about his thinking at the time. It was the middle of winter. He was struggling. He had walked, a substantial amount of time. I think he just got himself to where he made a poor decision. Not even necessarily because he didn't feel he had any other choices, but just out of frustration. He did also in this day, have interaction with the police after this happened. When they actually got the call to go get him, hey, he cut his tether off. They knew, they said, oh, we just saw him at a gas station. So otherwise, other than doing this, he wasn't trying to steal from anybody. He wasn't attacking anybody. I understand he's here. It's a crime. He shouldn't have done it, but he didn't cause society of any real trouble this day. other than cutting off his tether. Obviously, that's not a good thing. That's why he's here. But he was not in a good place at that time, and it doesn't defend it, but that's just why. I think he was, homeless in the snow and gave up on that. I understand the recommendation for the year. Obviously, anything less would be greatly appreciated. You don't know, and I think maybe that's the larger question. And I think the report is hoping maybe that if he does get a substantial jail sentence, that he'll just be done with his parole and can be off and can have a chance to try and go forward without any conditions. It's his intention, I think, to move to the Adrian area. It's where his children are. It is something that he's told me even before all this happened, he had wanted to get to that area, and is hopeful he can reestablish himself in a better situation down there. Thank you, Honor.
Thank you, Mr. Bucco. Anything you wanted to say today?
Just want to say that the comments thing, I think that makes it was a little worse than what it really was taken, I think. And I just want to get sober and hopefully get a fresh start.
Okay. I did read through the report. I'm familiar with your background and your circumstances. I'm also familiar with what happened in this case and why you're before the court here today. And there's not a lot to be said. Your record is what it is. You know what it is. It's substantial. And I think what I look at in terms of sentencing on this charge is the deterrent effect. That's the goal I think that we're trying to achieve through sentencing here. When somebody's placed on tether, it's an opportunity for them to be out in the community. When they tamper with that device or cut it off, that's something that we want to discourage. And the way to discourage that is by giving somebody time for doing that. And so I think that's the goal of the court here, both the deterrent for you. If you are placed on a tether in the future, you'll understand that you're going to face a lengthy jail sentence, at least for that. And other people who are put on tether, that they understand that that's something that is not acceptable and that is going to be met with some consequences. So I think the sentence recommended in this case of 12 months accomplishes that goal. And so the court is going to follow that recommendation. The court is going to sentence you to 12 months in the Kalkaska County Jail. You do have credit for 114 days served. That is also per probation's note to be served concurrent to any parole violation. There is a crime victims assessment of $75, court costs of $325, attorney fees of $350, and a $53 state cost that the court will impose as well as part of the misdemeanor charge. You do have the ability to seek an appeal of this sentence. Because it's a misdemeanor, you would not receive any paperwork explaining your appellate rights. However, if you had any questions about that or wanted to file an appeal, Mr. Travis would be able to answer any of those questions for you. Good luck to you going forward. You are remanded to the custody of the county.
Thank you.
Were you ready on the Spencer's case?
We are.
People versus Emma Spencer. And this is file number 265204. The record should reflect Ms. Spencer's present here in the courtroom today. Mr. Travis, can you tell me just this?
Yes, Your Honor. We waived the prelim in this matter on an offer to resolve the matter under a 7411 plea. We had talked about that today. Ms. Spencer and I were talking. Apologize for that, Your Honor. About some other things, and actually would like to ask the court for a 30-day adjournment because she's raised some questions to me that we hadn't talked about until just a couple minutes ago that I think I should take some more time with her to discuss, basically. All right, this is it good.
I don't have any objection now.
All right, this matter was found over in May, is that right, Mr.?
That sounds about right.
May 18th.
Yeah.
I was confused because we've got some wrong papers in this file. All right, Ms. Spencer, I just want to double check her address. Can we confirm an address for you? It looks like we had mail. Is it on Island Road there?
No, I moved and I changed my address, but it's 9343 Blackman Road, Kingsley, Michigan.
Oh.
I changed it with you guys last time I was here.
Did you?
9343 Blackman? Yeah, Blackman Road, Kingsley.
That's the code?
49649.
Okay, out.
All right, so we'll set this for a plea hearing in 30 days. So Ms. Spencer, between now and then, you need to make sure that you stay in touch with Mr. Travis.
Yeah.
At that next hearing, I'm going to be asking you for a final decision about whether you want to accept any plea offers. And so you need to be ready with the final decision on that date.
Thank you.
Okay. Do you have any questions about that? Mr. Travis, anything further?
Nothing further. Thank you.
Thank you. That's all for today.
In your honor, I do have Ms. Howe next, but I haven't had a chance to speak with her. If I can have a couple minutes.
Okay. We're a few minutes ahead, so let's take a break until 10:30. Okay, so I believe, Mr. Ziegler, we have an agreement as to OB3, is that correct?
That's correct, Your Honor.
Okay, so the court will order that OB3 be scored at 0, which changes the total OB score to 30 as opposed to 35, but I believe that does not result in any change to the guidelines, is that correct?
That is correct.
Correct.
Mr. Travis, did you have any additional argument that you wanted to make with regard to the scoring of OB9?
I do not, Your Honor.
Mr. Ziegler.
Your Honor, I think everything's adequately addressed in my memo.
Okay, so OB9 involves the risk of injury to any alleged victims, and it allows for scoring of, scoring of 10 points when 2 to 9 victims have been placed in danger of injury. In this, the court has to find that scoring is supported by preponderance of the evidence. The court can rely on sworn testimony, information contained within the pre-sentence report, victim impact statements, as well as police reports. In this case, the people did attach as Exhibit 1 to their response a copy of the police report that was generated in this case. I did have a chance to review that report, which included narratives by both Sergeant Bellinger and Deputy McCormick. And having reviewed those reports, both of those officers, Sergeant Bellinger indicated that Ms. Howe kicked and attempted to kick him during the course of her arrest. Deputy McCormick also testified, or also placed in his report, that Ms. Howe kicked him with her right leg. Also, that she continued, both officers gave information in the reports indicating that during the arrest, she continued to pull away, continued to kind of go limp and be dead weight. The court finds that all of those things, including kicking, are actions which could have placed either one of those or both of those officers in danger of potential physical injury, even if they weren't actually injured. So for those reasons, the court finds that there's preponderance of the evidence to support scoring of OB9 at 10 points, and the court will deny that challenge. Then the last challenge was to OB12, contemporaneous felonious acts. Mr. Travis, did you have any additional argument on that one?
No additional argument, Your Honor.
Mr. Ziegler.
No additional argument, Your Honor.
Okay, the scoring of OB12 is supported at 5 points, where there's at least one contemporaneous felonious act. It has to be within 24 hours of the sentencing an offense, and it can be an offense that is or will not or has not resulted in a conviction. In this case, the court finds, based on the information contained within the same police report that I identified earlier, that there was another individual that was assaulted with a weapon, knife, And the court finds that based on the information contained within that police report, that there is a preponderance of the evidence to support that Ms. Howe did commit at least one other felonious act, and that is assault with a dangerous weapon, that knife committed upon Mr. Luzardi. And based on his injuries that were observed by the police officers, again, the court finds that would support, and his statements that would support preponderance finding. So the court will score OB-12 at 5 points and deny that challenge, which leaves the guideline range at 5 to 23. Mr. Travis, did you have any additional challenges to the scoring?
No additional challenges, Your Honor.
Mr. Ziegler, did you have any additions, deletions, or corrections to the report?
No, Your Honor.
I should note, I guess, for both counsel, I did get an attachment from Mr. Ziegler's office, a police report indicating that on July 4th, Ms. Howe had some police contact. Were you aware of that, Mr. Travis?
I was. It was also forwarded to myself.
Okay. So I want to make sure the record's clear that the court is aware of that. Did that result in an arrest, Mr. Ziegler?
No, the parties were separated for the evening and the report was sent to my office.
Okay. Did you have any challenges to the scoring, Mr. Ziegler?
I do not.
Anything on, you have a victim that wishes to address the court?
I don't believe Mr. Luzardi is present, Your Honor. Neither of the officers wish to make a statement.
All right. Anything on behalf of the people for allocution?
Your Honor, the recommendation is for 24 months probation with some upfront jail. I think that's an appropriate recommendation. First and foremost, the defendant has a relatively poor criminal history with 4 felonies and 10 misdemeanors, all out of Georgia. What caught my attention in reviewing the PSI, Your Honor, was not necessarily the things that she was convicted of, but the fact that in both item 3 and item 4 in the criminal history section, she was charged with possessing a knife during the commission of those crimes, and that charge was ultimately dismissed in both cases. That seems to me to be a pattern where the defendant engages in criminal activity while in possession of a knife. Second, her behavior in this case was particularly poor. Setting aside the, I'm sure, disputed facts about the felonious assault and just focusing on the R&O, she was being detained by law enforcement for what was clearly justified concerns, at least, about assaultive behavior that she had engaged in. Instead of complying, she made it as difficult as possible for the officers to do their jobs. She ran from them. She assaulted them. She went limp, making herself dead weight, having to be carried about. She kicked both of them at different times during this scenario. Even just looking at those facts, Your Honor, with nothing more, it's clear that some jail time is warranted. Third, to add fuel to the fire, as the court's referenced, with their sentencing just 3 days away, she's allegedly committed a new act of domestic violence against her new significant other while on bond. While these allegations are unproven, it's unclear at the moment whether we're going to charge. The court can consider any facts that it finds true by a preponderance of evidence, and it can rely on police reports to find things by a preponderance of evidence. I think this new report simply just goes to show that a simple term of probation is insufficient to deter her conduct. I would also note, as the court's aware, she has at least one other warrant for her arrest that further demonstrates she's unlikely to do well on probation alone. Given all of that, Your Honor, I think an upfront sentence of jail or even prison would be justified on these facts. With guidelines of 5 to 23, a 12-month sentence would be below the middle of the guidelines, and I think a middle of the guidelines sentence would certainly be justified on these facts. This was not a below average or below the middle of the road R&O. This was what I would consider on the higher end of an R&O, short of someone being physically injured. Her conduct on bond was certainly worse than average. Her criminal history is certainly worse than average. I think the recommendation of a 12-month sentence followed by a term of probation is a very fair sentence under these circumstances. And I would ask the court to impose that.
Thank you. Mr. Travis.
Thank you, Your Honor. Your Honor, it was noted in that police report and somewhat noted in the PSI, Ms. Howe
does suffer from a closed head injury to the best of my knowledge. And I would say just my interactions with her demonstrate that. I'm not alleging that she's not competent. She knows who I am. She knows why she's here. She appeared here today. Her and I weren't able to speak in the week leading up to this because her phone wasn't working. So I don't want to imply anything of that nature, but I have seen her get confused in the matter of 20 minutes about things. So I'm not a doctor, but I definitely believe that's true. She's got some serious back issues she may talk about that. So she has a number of medical issues she's dealing with right now. And I don't know how consistent or how well that's been being dealt with, but I do know she does have these issues. She's just demonstrated them through her behavior. She's trying to work on that. She indicated to me that she does have an MRI scheduled in the next month. As we know, with the history from Georgia, her daughter is down there. She is primarily from Georgia. I think a string of kind of bad circumstances led her to kind of stay in our area longer than she intended. Car problems, work problems, and then obviously now criminal problems. It is her desire to go back to Georgia. I understand that there are warrants out there, but she wants to get back there. Her daughter's there. She often talks to me about her desire to get back to her daughter and be in Georgia. Thankfully, her daughter is, I believe, living with her sister. So she is with family. She, I think in general is just struggling. I mention a lot of that because it's the court's purview, but I question how beneficial probation would be for her. I realize Mr. Ziegler wants to see a larger jail sentence. I would ask Your Honor to consider something towards the bottom of the guidelines. At 5 months, that's a pretty substantial, if Your Honor were to stay within the guidelines, it's a pretty substantial sentence for an R&O without an habitual offender status. I realize her criminal history brings her to that, and the offense variables that we previously discussed also bring her to that, and that we have to deal with that. But I would ask the court to consider a still somewhat extensive jail sentence, but something closer to the bottom of the guidelines. And it's not as though that she would not try to do probation. I just have seen her get confused about things a lot, which I think may end up causing issues with probation later. Thank you, Your Honor.
Thank you. Ms. Howe, is there anything you wanted to say today?
Yes, I apologize for everything, sir, but I just don't understand, or I don't think that jail time with my circumstances that are going on, all my appointments coming up. I have an MRI. I have one from my bladder. I have bladder leaking. I have a bar in my back from hip to hip, and I have a lumbar up my spine, and I have to take care of it, and I have to take care of it every day. Like I have extreme amounts of pain. And I have a lot of doctor's appointments coming up for my concussion, for my bladder, for my gastrology, for my MRI, for my heart. All sorts of stuff that's going on. I have a schedule coming up. It's just going to prolong the process of doing better. And that means I wanted to be on probation and stuff the other discussed about. When I came down to Georgia, I took a first offender's plea bargain act. So all this stuff would be behind me. When I had my daughter, all that stuff in my record was behind me. I took first offender's plea bargain act so I could be not a felony to raise my daughter normally. And this is just prolonging the process of doing better for Faith. I'm trying to do the best I can. And the other day, there was no touching, nothing. It was talk about the other day. It was just got out of the ordinary. But I'm a law-abiding citizen. I'll do anything you ask to probation or classes or anything that pertains to me, as long as I can get back to Faith. But I just don't know. I don't see how jail time is going to help anything. Because I do have a lot amounts of pain that I'm dealing with. I'm dealing with my concussion. I had to learn how to talk again. I had to learn my memory is really bad. But I do take a lot of medicine and I'm switching medicines to see what one's the best for me, considering my concussion and gotten the best of me and my anxiety and stuff like that. But I've been staying here for this court date so I can see what's going on so I can go get back with my daughter. And it's just a little bit overwhelming, you know, when I'm trying to do good, I'm trying to do the best I can for her. But I haven't been able to see her. I got into a wreck in June. I stayed in the hospital for 7 months. And then I got out how to learn how to walk and talk and everything else again. And then 3 months later, I got into a wreck and I got stuck here. I started working in a manufacturing plant. I wasn't able to do what they wanted me to do. So now I went and applied for Social Security. So I'm just gonna sit there and not do anything productive for my life or my daughter's life. And she's gonna start school next year. So it's a lot in my behalf.
Okay. All right. Well, I read through the report. I'm familiar with why you're here before the court today. Obviously, I read through the police report. So I got the officer's description of your actions that night. And there's also a lot of information in that report about you and your circumstances and your history. And so I take all of those things into account, along with what the lawyers have had to say here today, as well as yourself. And, you know, I do think you have some issues going on here that need some treatment. And I hope that you follow through with that. I think the actions that you undertook on that night and are alleged to have undertaken just a couple days ago indicate that you've got something going on that's causing you to act out in a way that normal people don't act out in. And the concerning thing is that you act out in a violent way and that you cause injuries to other people. And so the court, you know, has an interest in discouraging and deterring that kind of conduct and punishing it so that you understand that that's not good behavior. That's not the way you're supposed to interact with other people. And you've been on probation a number of times in the past. Based on your past history, it indicates you've had 5 prior terms of probation. I don't see the point of putting you on probation in this case. I think that's setting you up for failure, number one. And if 5 prior terms of probation haven't worked, I don't see how another one is going to help at this point. So I don't think it's worth the community time and resources to put you on probation. I think a straight jail sentence is appropriate to punish your conduct in this case and provide some accountability to you for the injuries that you caused to the other individual involved and the resistance, physical resistance that you pose to the officers on scene and the potential danger that you put them and yourself in by your conduct through the course of this incident. And I do take into account the fact that you just had law enforcement contact when you're on bond. You're supposed to be behaving yourself, and you clearly aren't able to do that even when you're on bond. So the court finds that a sentence within the guidelines is appropriate. The court is going to sentence you to 10 months in the Kalkaska County Jail. You do have credit for 2 days served. The court is going to impose a crime victims assessment of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost. You do have the ability to seek an appeal of this sentence. And Mr. Travis, if you can have Ms. College knowledge receipt of her appellate rights, please.
Yes, sir.
See. You're already managed the custody of the county at this time. Yeah, Mr.